Hello. Assalamualaikum warahmatullahi wabarakatuh. I think organizer we can start now, right? Yeah. Okay. Got it. Okay. Assalamualaikum warahmatullahi wabarakatuh. Very good morning. Selamat pagi, everyone. I couldn't see the list of participants, but just to be on the safe side. Of course, Yang Bahagia Tan Sri, Dato' Professor, Your Excellencies, our distinguished speakers and colleagues. I am Andika, a fellow and also a senior lecturer at the National University of Malaysia, UK, and I will be moderating this session, thematic priority on labor. And I hope that you had a chance of joining various sessions yesterday, because there's a momentum that we are building on that session. And of course, the first session that we had just completed with the EU delegation minutes ago. And I would like to take this opportunity to congratulate the organizer and organizers for your trust inviting me to moderate this session. I think before we get started, let me just highlight a few important notes. I think the first one is that it is, as you would appreciate, that it is a dynamic and open dialogue. Hence, I strongly encourage panel speakers to be, of course, open and frank throughout the session. And second is that this is a dialogue format, and we do not encourage the use of PowerPoint slides. But if you intend to use one, you can do that in the first one, but limited to say about 5 slides. And also just to let you know upfront that I was also given the sort of a blessing by the organizer to ask you additional questions if I wish. So I will do that, if I see the opportunity to ask additional questions. The third point is that this session will be divided into 2 rounds. The first round number 1, we have 5 panel speakers. Each panel speaker will be given about 10 minutes to share their thoughts, and then we open for 10 minutes Q&A. And we proceed to round 2. Round 2, we will give about 5 minutes to each speaker, and then we open for another Q&A for about 10 minutes. For participants, you can use the chat box, the chat box function, and to ask your question. I will coordinate the question and also get the assistance from the UN office to see the question. But I just note that please be specific in your question and dedicate your question to whom the question being asked or dedicated to. And finally, we will invite all the speakers again to provide their final thoughts, about 2 minutes, and then we conclude the session. Now, before I introduce you our 5 panel speakers, as I mentioned before, let me just quickly provide you the sort of the background of this session so that we can put the right context, the tone as well for our session today on labor. And as you would be, I think you already know that labor has been identified as one of the thematic priorities for our future National Action Plan on BHR. I think it is not unconventional. It is common, and other countries have also prioritized labor in their respective NAP BHR. I think we have more than 20 countries that have actually developed the NAP. However, it also must be emphasized that labor issues, the barriers relate to issues on labor, and the bottlenecks are not the same across different countries. And even within the same country, we have different, kind of varieties in terms of the sector. Some countries may rely on domestic labor force, for example, and others heavily dependent on international migrants, like Singapore, Thailand, like Malaysia ourselves. And from the sectoral perspective, while some sectors are able to move to mechanization and automation, other sectors are still relying on manual, low-skilled workers, temporarily contracted workers. So we see the variation as well from here. In the past years, we have also shown we have seen the prominent role of migration industry. Migration industry meaning the recruitment agencies, individuals involved in the migration, shaping the supply and demand across different migration corridors. So we have different corridors that supply workers to Malaysia. The same with other destination countries like Thailand or maybe countries in Middle East. So where governance gaps and unethical practices happen or still exist, workers face risk and face risk of manipulation, deception, and sometimes eventually lead to greater risk of forced and bonded labor alike condition, not just during the recruitment, but also when they come to the destination country. Now, you would also I think we should also relate that to the spread of COVID-19, where it has actually further worsened the workers' vulnerability. And at the same time, also reveal emerging group of workers who are not covered in what you call so-called the mainstream legal protection regime, such as workers in the gig economy. Yeah. So besides, there has been also a growing concern with regards to workers' data privacy and protection, and barriers facing segments of workers, for example, workers of undocumented migrant workers to access vaccination and healthcare treatment and in fact access to virus containment efforts. Yeah. And to be fair, businesses have also taken efforts to help alleviate issues or address issues facing workers. Continuous compliance to COVID-19 SOP and labor standard compliance help in making sure workers are protected during this period. So with the pre-existing and emerging labor issues during the course of the pandemic, the question arises as also to relate to the NEP BHR. How do we then expect the NEP BHR address these issues pre-exist before the COVID and also during the COVID and post-COVID? That's the first question. The second question, the big question, this question, how the NEP BHR can build on what we already have today in terms of the laws, in terms of the policies that we have, the programs, the resources, and bring together different actors and partners. We have different partners actually in the same space, can contribute and implement BHR. And importantly, what added value are we offering to the NEP BHR as compared to other national action plans? We will discuss that later with MOHR and the rest of the panel speakers about the existing national action plan. We have national action plan on trafficking in persons. In future, we will have national action plan on forced labor. So what the difference or what the added value the NEP BHR would offer to the existing national action plan or other development plans that we have. So as promised, I will explain to you just provide you a little background of the 5 panel speakers we have today. They are the subject matter experts and also advocates. So let me start with Mr. Bashar Bachi, who is now the Deputy Undersecretary at the Policy Division, Ministry of Human Resources, MOHR. He served about more than 20 years at the ministry, dealing and leading work related to unfair dismissal cases, trade dispute, trade union matters, and law reform. So I welcome Mr. Bashar in the panel. And the second is Mr. Guachayan, or Freddy Guachayan, who is now the Program Manager for Supply Chain in Asia at the International Labour Organization, ILO. So his work or his portfolio focused on private sector development, socially responsible labor practices in global supply chain, specifically in Asia, or in Asia. So I think we would count on Mr. Guachayan to provide us some regional perspective on the labor issue. And the third speaker, I think he doesn't need an introduction, but I think still my duty to read the biography of Yang Bahagia, Dr. Wajid Samsudin. So Dr. Samsudin is the Executive Director of the Malaysian Employers Federation, MEF. And for your information, through my quick search online, but it has to be validated by him. The members of MEF employ nearly 3 million employees. So 3 million employees equals to about 20% of the total labor force in Malaysia. Yeah? And MEF has more than 5,000 ordinary company members and about 20 association members or associated members. We would imagine the kind of leverage the MEF has and the impact it can make and bring them on board. And the fourth speaker is also a very well-known figure, Mr. Muhammad Fendi Abdul Ghani, playing a leadership role now, I think, for the Malaysian Trade Union Congress, MTUC. He used to be the deputy president before. And for your information, MTUC represents workers in almost all major industries and sectors in Malaysia, you name it, whatever the sector is. And with approximate workers about 500,000, I think about 500,000. But I think Mr. Muhammad Fendi can confirm that later. The last speaker, I think it is not complete without CSO, participation and contribution as well. I think we have Mr. Adrian Pereira, who is now the Chief Advocate. People use, Executive Director, but he is Chief Advocate and co-founder of the North-South Initiative. So for your information, NSI is a human rights and social justice organization with, I think, the mission to build an inclusive society that also promotes social justice through solidarity building. Now, I've done the first 2 tasks. Now, let's get started with the first round. I will start with Mr. Basha first. Apologies for my long introduction. Mr. Basha, in the first round, we will have 10 minutes. We will have 10 minutes to respond to this. The questions that we already have the National Action Plan, Trafficking in Person, 2021-2025. The third version is the third series, supposed to be a fourth series, fast and efficient. And soon we have the National Action Plan on Forced Labor. And some part of the NAPTIP and also forced labor soon will be under the purview of MOHR, definitely. Now, the question we have two. How do you see NAPTIP and forthcoming NAP on forced labor would complement and align with the NAP on business and human rights? That's the first question. The second question, how do you foresee the emerging gig economy, as I quickly mentioned just now, the gig economy today, and the potential consequences to labor rights and protection for informal workers, because they are informal workers given the unconventional employer-employee relationship in the gig economy. So I would appreciate if Mr. Basha could explain these two questions or can reflect on these two questions. Mr. Basha, not the floor, the screen is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh and very good morning. Thank you, Dr. Andika Wahab, moderator of this session. Good morning to others panels from ILO, MEAF, MTUC, and North-South Initiative. So on behalf of Ministry of Human Resources, I would like to furnish our appreciation to Legal Affairs Division, Prime Minister Department, BHU, SWAHCAM, and UNDP in organizing this meaningful discussion session and provides a platform for the ministry and the stakeholder to meet up and share opinion on the issue of labor with business and human rights. Okay, before I answer the question directly, I would like to share a rough pictures of Malaysian government in handling the labor issue, including the policy and legislation framework, access to justice and legal remedies, international standard, as well as the way forward in this issue. Ladies and gentlemen, regarding to the National Action Plan, Business Human Resource and interrelation with the NAPTIP and the National Action Plan for Forced Labor, the most important thing is a legal framework itself, or legal framework itself. So these are the current labor laws that actively practicing in Malaysia. There are 28 laws in total, which 25 of law are under the administration of MOHR, and another 3 laws enforced by MOHR, namely Anti-Trafficking in Person and Anti-Smuggling of Migrants Act 2007, or we call Act 670. This the main act under the under purview of MAPO. It pertinent to the NAPTIP 3.0. And another one, prevention and control of Infectious Disease Act 1988 at 342 and Petroleum Safety Measure Act 1984. So here I would like to share some labor law reform that have also been included in NAPTIP 3.0 and also in the draft of National Action Plan for Forced Labor as initiative on the issue of forced labor. So the government is amending the Employment Act and the Workers' Minimum Standard of Housing and Amenity 1990, or we call Act 446. So when to amendment of Employment Act, it's aimed to increase the right of workers in the workplace by creating provision on flexible working arrangement, reduce working hours, prohibiting discrimination, promoting a work-life balance culture for the workers, and introducing a new provision on forced labor by providing penalty and forced labor offense. So while the amendment of the Act 446 aimed to provide a conducive accommodation for workers and introducing centralized labor quotas, CLQ, there's a new one in the Act. This is the one of the elements to overcome the issue of forced labor in Malaysia. The application of this Act is also extended to Sabah and Sarawak due to threat of COVID-19 for the workers. And for the Private Employment Agency Act 1981, Act 246, has amended in 2017 to provide strict liability to employment agency to adhere to the laws by imposing bonds according to their respective license of recruitment. So the past conviction of the middleman of agent on trafficking in person or tip or forced labor will be considered when granting license. If the private employment agency are found to be involved in the trafficking in person and forced labor activities, their license will be revoked or suspended. That's the control we introduced under the amendment of this Act. So the another ones, the minimum wage order gazetted on 10 January 2020 and came into operation on 1st February 2020 by stipulates two different set of minimum wage rate based on place of employment in line with cost of living. For example, 16 city council area for 40 municipal council areas, minimum wage set as 1,200 ringgit per month, and others location is 1,000 ringgit per month. Beside local workers, this law also applies to foreign workers who work in Malaysia with legal document. All these four labors law can be considered to include in National Action Plan on forced labor with on business and human rights or National Action Plan for business and human rights also. So when we study the strategic goal of the National Action Plan for TIPS, Trafficking in Person 3.0, the strategic goal almost based on the legislative framework, such as review and strengthening of legal and policy framework, improve of protection mechanism, strengthening of collaboration partnership. That's also stated in the National Action Plan for forced labor, such as increased awareness and understanding. A second one, improve data collection, migration management, improve access to support and protection services, so that the correlation between NAPTIP 3.0 and National Action Plan for Labor, and also we can bind it together with National Action Plan on business and human rights. Okay, maybe I straight away go to the second question on the access to justice and legal remedies. For the right now, Ministry of Human Resource introducing working for workers application. So where both local and foreign workers in Malaysia could lodge a report on labor-related complaint throughout this app. So no need. So there's another alternative beside going to the nearest labor department or agency under the Ministry of Human Resource. The workers can lodge a report through the Working for Workers application. So another one, the Industrial Relation Act 1967, or we call Act 177, has been amended in the line with the Principal Comprehensive and Progressive Agreement for Trans-Pacific Partnership, CPTPP, Convention 87, Freedom of Association and Protection to the Right of Organize, and Convention 98 also, the right to organize and collective bargaining. So furthermore, the Industrial Court and Department of Industrial Relations is handling any dispute between the two parties, employer versus employee, or employer union versus employee union also. So another field for the workers to have a remedy or report to the Department of Labor is one of the main enforcement agency to handle labor complaints, including eradication and addressing sexual harassment in the workplace and retrenchment. This agency also organize outreach activity like labor education and promotion program for the industrial community. And
Mr. Basha, you have another 1 minute.
All right. Okay. Furthermore, the ratification of ILO Convention 29, C29 Forced Labor Convention, also another platform to collaborate with the international party and the issue of forced labor. So, ladies and gentlemen, as a member of ILO, the government aware of the ILO perspective in various labor issues handling forced labor. So, as for now, Malaysia has ratified 27 ILO Convention, which can see in the list. We have 3 categories, namely Fundamental Convention, Governance Convention, and Technical Convention. So in order to improve the human right protection of the labor and also businesses, the government will keep continuing reviewing and amend the related labor laws, enforce and monitoring the workplace, engage with the stakeholder, trade union and CSO also, and collaborate with the international parties such as ILO, United Nations, TIP US Department of the State. Okay, so with the above information I share, I hope it could present you pictures of the effort of the government, especially Ministry of Human Resources in the labor issues, particularly the issue of forced labor, migrant workers, and all related to the labor. Thank you, Doctor.
Thank you, Mr. Basha. We will have a Q&A session later on. I just let you know upfront, there's a question about what does the MOHR, whether MOHR intends to ratify the ILO Convention 190 on violence and harassment in the workplace. I think you can address that in a Q&A session. That's the first question. I have another question, but I think I will repeat that. I will say that in the Q&A session. The other thing also, Mr. Basha, if you can also explain a bit on Malaysian efforts to strengthen our hours of work commitment on par with the international standards. You would imagine the excessive hours of work that the workers are working, the approval given to them more than 60 hours or more than 72 hours in a week, or 104 in a month overtime, for example. So on the standard of the hours of work, if MOHR can provide a little bit background on that, or what efforts MOHR are looking at in terms of strengthening that part of the labor standard, maybe Mr. Basha can explain that in a Q&A session. Yeah. So these are just upfront questions that you can address. The gig economy, maybe later on, if we have more time, I think we can do that in the second round. Yeah. So now let's move to second speaker, Mr. Guachayan. So we see actually a growing thread of dispute, threat dispute and sanctions. Yeah, everywhere else now. I think not just Malaysia, China also has been in the list of the CBP, for example, for the US threat sanctions. In the region, especially in our region, on issues related to forced labor and child labor. Now, from the regional perspective, how do you see the effect of this sanction to the state, the social partners? And in fact, if you can elaborate a bit on the business side, yeah. So what would be what are the effects of this threat sanction? That's the first one. Second, what can we learn from that as we go ahead developing our NEP BHR? What should be mainstream in our NEP BHR so that we can be mindful of that or what step that needs to be undertaken. The third one, do you see that we are responding, especially in maybe in the region, or if you have more knowledge on how Malaysia is responding to that? Maybe you can elaborate that. How do you see we are responding to this, development in the threat and dispute sanction, dispute and threat sanction, effective, whether effective or sufficient, not sufficient. So hope that, yeah. So Mr. Gordon, you have about 10 minutes, yeah?
Yeah, thank you very much. Do you hear me well?
Yeah, very clear, loud and clear.
Yeah, good morning to all the audience, to all the participants on behalf of the International Labour Organization and on behalf of the Responsible Supply Chains in Asia program, of which I am the program manager. My name is Freddy Guayacan. I'm happy to contribute to this discussion panel on these questions. Indeed, in the region, there has been a trend. I wouldn't say of sanctions, but I would put it rather on the way than there has been an increasing awareness, and of course, I mean, some sanctions have been put in place in context of trade, but also in context of investment related to labor. And this is very much because, indeed, countries in the region engage more and are more active in the engagement when it comes to trade, when it comes to commerce, when it comes to investment. With other countries, like, for instance, of course, the European Union, United States, Australia, United Kingdom, countries which indeed already have in place legislations, or as it is the case in the modern generation of free trade agreements, of sustainability clauses, which refer to the international labor standards and more specifically to the fundamental principles and rights at work and the compliance with those, as well as with other key instruments such as the UNGPs, the United Nations Guiding Principles on Business and Human Rights, as well as the guidelines for multinational enterprises of the OECD, and the ILO M&E declaration, of which we will talk later on. This is having, of course, a great effect on the private sector as well as on the public sector and on the policymakers. On the private sector, this is having the direct effect of which is a good positive change in the change and the adoption of the business practices. So socially responsible labor practices are increasingly being adopted by the private sector as a result of these actions or of these calls for them to be aligned with international labor standards and with international responsible business practices. And of course, increasingly the private sector, they see on the implementation of responsible business conducts at CSR, not only a requirement for them to access the new markets, but also a factor for increased competitiveness and productivity. On the other hand, there are also institutional changes, important institutional changes. I think what was already just mentioned by the Deputy Director General, highlighting all the changes on the legal framework, highlights some of the important progress that the country is doing, and this is also the case in other countries in the region in terms of changing institutions, regulations, rules. Important also to highlight the need for the governments and for the state through their respective agencies to provide business development services for the small and medium enterprises, for them to implement these socially responsible labor practices. And of course, as a result of this, I would say, there has been also a motivation to trigger the interest and the active involvement by governments on the and the engagement on the design on the national action plans on business and human rights, for which, of course, the political and social dialogue and the involvement of key actors remain a key aspect. When it comes to the learnings from the region, and specifically to the National Action Plans on Business and Human Rights, which is a recommendation from the United Nations Guiding Principles on Business and Human Rights, which I mean, I have to highlight that we work hand in hand with UNDP in many of the countries, and UNDP has been very active in supporting governments and other partners on these dialogues. In October 2019, Thailand adopted its National Action Plan on Business and Human Rights. It's prioritized four areas, which are four thematic areas. The first one is labor, the second one is environment, the third one is the protection of human rights defenders, and the fourth one is investment. So giving some great importance and emphasis on the labor aspect. I think if you allow, I mean, this will be an interesting learning. Japan also recently has also adopted its National Action Plan on Business and Human Rights, and also prioritizing the aspect of labor, and emphasizing on some specificities such as the promotion of the decent work in general, but also to reinforce some measures against harassment and protect and respect the rights of workers, including migrant workers. So I think this is to be highlighted. As general learnings, I would say coordination comes as one of the important learnings, because indeed it is important not only to coordinate within the government with the different departments and institutions and ministries in charge of dealing with these aspects, but also coordinating with the private sector and with other key and important actors, such as the social partners. So the involvement of the trade unions, the workers' organizations, well, in the case of Malaysia, of MTUC is key, as well as the employers, the MEF, and I mean, to legitimize these action plans, but also to give, I mean, some substantial feedback in the design stage of the National Action Plans on Business and Human Rights. So partnerships and coordination remain important in the design, but also then therefore in the implementation of these national action plans. Well, needless to say that the active involvement of the private sector, generally through the employers' organizations and the business associations, but also specifically on some specific sectors than has had more challenges in terms of implementing decent work practices and international labor standards at the factory level or in the field are important. Of course, I mentioned in the field because agriculture, as you might be aware, is one of the sectors that requires some work in terms of advancing this agenda of promotion of decent work and international labor standards. Are the current responses sufficient? I think a big and significant progress has been made at the regional level, well, at the country level, hearing all from the Department of Labor, the progress that there is in terms of ratification of conventions, but also in terms of the implementation of a legal framework. Well, this is important. However, there is a need to do more work and efforts to indeed tackle the different issues that there are when it comes to decent work and labor in specific sectors, but particularly in the lower tiers of the supply chains. I mean, because they are populated by mostly micro, small and medium enterprises, and also because many of them are informal. Well, I would like to also highlight here that indeed, I mean, when it comes to the ratification in the context of Malaysia, when it comes to the ratification of the fundamental conventions, I mean, two conventions are pending to be ratified: the Convention 111 on discrimination, as well as the Convention 98 on the right to organizing and collective bargaining. So these are important and indeed fundamental conventions, and I would say that this is very much as on the pendings well, at least at the national level. But of course, then after the ratification comes the inclusion into the national legislation and the respective implementation. Just for the last minute that I have, I would like to highlight on some quick challenges that would be, from our perspective, important to emphasize. The first one that has to do with COVID, with the current context. I mean, this is a huge game changer from different perspectives for the businesses, of course, but also for the workers, from the aspect of occupational safety and health, from the types of contracts, but also in general from the labor practices. The future of work and the gig economy, I mean, this necessarily needs to be included. It goes and it links up upon topics such as informality, of course, migrant workers, and this is something that needs to be addressed and discussed with the different trade unions and workers organizations, and of course with MTUC and MEF as social partners in the country, and the inclusion of the gender aspect. I mean, from the different aspects, from harassment, but also from the barriers that women face to access managerial positions in companies. Important here to give the voice not only to the formal sector, but also to the informal sector. As it is of your knowledge, almost 98% of the enterprises in Malaysia are SMEs. We are talking about roughly 650,000 of them, many of them informal. So how to give voice to the informal sector? Because indeed, well, this is an area that requires attention in order to address well, critical issues when it comes to labor. I would say this is very much from our side, and happy to answer questions and then further develop in the subsequent question. Thank you.
Thank you, Mr. Guachayan. I think maybe in the Q&A session, because I have this question as well. And you rightly pointed out about the different capacities of SMEs and in comparison to large companies, public listed companies, government companies. So my question is that maybe in the Q&A session, if you could reflect that, the question that always being on the top of my head is that the SMEs in this narrative, do they need a free pass in the UNGP BHR, or do they need a flexibility? So if they need a free pass, meaning they are not in the framework, now we don't reflect them, because that's the kind of narrative we try to understand now. That's one. Whether they need free pass or flexibility. And in other countries, if you can share with us how best we can reflect the kind of flexibility, if they are in the bracket of flexibility given to them, what kind of provision or incentive that we can introduce in the UNGP BHR so that we can bring them on board, rather than leaving them behind from the entire journey. Yeah. So that maybe we can reflect that in the next session. Now I move to the third panel speaker, that's Samsudin. What are the among the common issues, or maybe some critical issues facing businesses with regards to labor standard compliance? And I would imagine that because the big chunk of your members are in the SMEs bracket, right? And what are these issues? And how do you see the NEP BHR could address that? Also bear in mind that we have NAPTIP, we have NEP on forced labor, or there may be some other national action plan that relates to development and also labor in a way. So how do you see the NEP BHR specifically can address the issues that you face now among your member companies? You have 10 minutes, Joseph.
Terima kasih, Dr. Andika, and Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Very good morning to all the panelists and also the participants. Yes, indeed, when we are talking about the current issues that we are facing as employers, in fact, yes, it is very, very challenging indeed, especially when we are still deep into the COVID-19 pandemic, and of course soon we may be moving into what we call it as a COVID-19 endemic situation. And this is, of course, I think there is a need for a lot of clarity on the kind of things that we need to do as businesses, because the problem is if we are seen to be not able to comply with all the protocols, all the requirements, then of course there is this possibility of being fined and things like that. And of course, when we are talking about the current situation, the challenges we are facing very much is on the supply chain issue. Yeah, we had seen how during the pandemic itself, during the shutdown, quite a number of companies, especially the so-called essential services company, are allowed to operate. But you know, business is as such that the essential services company cannot operate without the full supply chain being in operation. So there are a lot of issues because what is considered as supply chain is in fact a bit blurring. You know, so say for example, if the rubber glove manufacturers are allowed to operate, and this company that provide additive to the rubber glove, to the rubber to be processed as rubber glove, if they are not allowed to operate, then of course it's impossible for the rubber glove manufacturing to continue operating. So these are some of the nagging issues that I think MEF have to deal with when we're talking about the supply chain issues. And of course, this is very, very critical. That this is why MEF is of the stand that, you know, the shutdown is not really, you know, working well. You know, we had seen still a high number of infections, things like that. And that's why we say that perhaps we should be allowed to operate, of course, complying fully with the SOPs that had been implemented by the government, and also to make sure that employees are fully vaccinated for those who are wanting to come to the workplace, things like that. So that I think is very, very critical. And of course, companies need to really, you know, comply with all the SOPs as had been implemented by the government, things like physical distancing and monitoring of the employees to wear masks, and also to make sure that the workplace is always safe and healthy. And of course, you know, when we are talking about, you know, companies' ability to survive, yeah, Freddie had mentioned that, yes, in the Malaysian context, many of the employers in Malaysia are basically SMIs. And for these kind of companies, their ability to actually remain in business without being allowed to operate can be very, very challenging. We had seen reports, not by the private sector, but by the government statistics department, to say that for this kind of companies, their ability to remain in business is limited to about 2 months only without having any kind of source of income. So beyond that, of course, for them to survive can be very, very difficult. So for this kind of companies, especially the micro enterprises, those are, you know, having 5 and less employees, things like that. So for them to basically, you know, they don't have any kind of savings or thing like that for them to survive. So they need to actually have their daily revenue kind of thing for them to survive. But if they remain to be shut down, and of course, their ability again to survive can be very, very challenging, because they need to actually pay for their fixed costs, things like wages, things like premises costs, things like that. And without any revenue, of course, it's going to be very hard. Of course, there is a need to actually for us to have a lot of flexibility. If, say, for example, these companies have only about 2 months resources to be sustaining themselves during the pandemic. So how do we actually make that kind of 2 months resources to be able to last them longer, say for 6 months or even for 10 months, so that at the end of the day, you know, then they are still able to survive and also keep the employees in employment? Because keeping employees in employment, I think, is the biggest challenge that many employers are facing. So question is that if they are asked to pay 100% wages, surely their ability to remain in business can be really very, very short. But if we are flexible enough to say that, okay, yes, we understand the situation, and so long as the employees are being given reasonable pay during this period where the employers are not allowed to operate, then of course, then we are able to keep the employees still in employment. And at the end of the day, when the government actually announced that all these companies can start to operate, reopen, then of course, then these employees have still a job to do. What is important is that I think it's very important for employers to keep these employees in employment, because if employers take the action of retrenchment or reducing the workforce, then for these people to find alternative employment can be very challenging, because just to share here that many companies during this period are actually embarking on policy, what they call it as employment freeze, and they will not take new employees for the time being. So it's very challenging for any employees that lost their job to really get employed. And of course, the important thing is that, it's very important for the government to keep the lifeline open, meaning that, of course, yes, the government had introduced a lot of policies on moratorium, thing like that. But the problem with moratorium is that it still attract interest, and the corporation involved has to pay a lot of interest on the moratorium period. And that's why MEF had always been asking the government to reconsider the position and give them a zero interest free moratorium during this period, because these companies, if they are assisted to survive during this period, then they are also able to assist their employees to be in employment. And at the same time, at the end of the day, we are actually making the labor market more stable, thing like that. Of course, it's really something that we had not seen in the I think for the last 15 years, that our unemployment rate now actually had passed the 4%. 4% is important in the sense that if your labor market is having an unemployment rate of 4% and less, by ILO standard, you are still considered as what we call it as in full employment. But now we are at 4.8%. And of course, worrying still, when we talk about the youth unemployment, those people between 15 years to 24 years, I think the unemployment rate is on the high side, possibly now is more than 12% kind of thing. So it is very, very important that these people need to be assisted to be employed. Of course, the kind of reports that we have also is quite worrying, in the sense that these graduates, diploma holders and degree holders are now competing with the SPM school leavers to find job. Yeah, meaning that all these people, of course, I think that the graduates, the diploma holders, I would say they are resourceful. They want to actually keep themselves, surviving during this period. And many of them had accepted what we call it as a step down employment, of course, with lower pay. But of course, we say that, this kind of phenomena may not be the long-term phenomena. Hopefully, when things go back to normal, then these people will, of course, be rewarded accordingly and be given a different position, so that they don't have to continue to do a lower job with, of course, with a higher qualification, thing like that. And of course, also what is important is basically when we are talking about, the situation of the country's, poverty line now. And of course, it is really, very disheartening to actually hear the report made by the Yang Amat Berhormat Prime Minister recently, that actually more than 500,000 households actually now had been, entering the poverty line. Yeah, those people, the 500,000 households, are formerly within the M40 category, the middle 40 income group, but now they actually within the B40 income group. 500,000, ladies and gentlemen, is not a small figure. And of course, it's very, very important that actually, a lot of things need to be done to ensure that this M40 should be going back to the M40 position that they currently are in B40, and of course increase the ability of the B40 people to move on to the M40 category, so that at least we are improving the situation, and of course at the end of the day we improve our standard of living, thing like that. Of course, the other challenge, Chair and also the panelists and the participant, is on the legislative aspect. Yes, we had heard from Mr. Basha how the government had actually tried to actually amend the legislation to be more proactive and meet the requirements of the private sector. But honestly, ladies and gentlemen, if you look at what is happening during the pandemic itself, of course, we do change the way we do work. Yeah, we mostly work from home during that period, and even currently, there are many people still working from home. But our legislation that we have is still stuck in a situation where we are actually being working from the workplace. And those issues that actually crop up for people who are working from away from the workplace really are not addressed. Yeah, so this, I think, need to actually be urgently looked at so that our labor laws can be more flexible to be catering for the new work environment. Because if we are not able to do so, then of course the situation can still remain as it is now and can still be very, very challenging for the employees and also for the company to manage the new relationship. How do we address all the nagging issues or all the issues that crop up arising from the work from home? And of course, another aspect is that when we say we work from home is, of course, the issue of connectivity. Yeah, I would say that there are at times we have bad connectivity, and while we are speaking, we got cut off, things like that. We have to switch off our video. But today, I would say that we are very lucky because our line is quite stable and we are able to communicate still and with videos on, things like that. But I had faced a situation where while we are having international conferences, the line was so bad, I need to actually shut off the video. But even that also, the voice is not coming up good. So this, I think, is something that I think the government need to quickly address. But of course, yes, we are trying to move to 5G, hopefully by the end of the year or early next year kind of thing, but still we are not able to resolve the current connectivity issue. And of course, so it's sad to say that actually some of the students in Sabah had to climb the tree to actually make sure that they have a good connection. And some of the people also have to go to somewhere, take a boat and take a ride and see where the best connection is and stop there. I think this is something that should not be happening, but it's still happening. And I think the telcos need to, honestly, I say here that telcos need to do a lot of investment to improve the connectivity. And another part is that, of course, to work from home, you need all the gadgets, you need to have a better laptop, you need to have a better smartphone kind of thing. So the important thing is that I hope this will be taken up in the 2022 budget to say that, yes, incentives should be given to both companies, both employers, and also employees to actually be given some tax incentive for them to actually upgrade their facilities, their gadget, thing like that, so that we all can actually improve our connectivity. And of course,
yeah, I think we have reached the time. But I just wanted to highlight this, Dato', because this is important, because you highlighted this, that there's this ongoing policy or freezing policy among the employers, right, among the companies. Yeah. And there's also, at the same time, there's a labor shortage in the business sector, I think, regardless of their size and place of operation. Now, the question is a little bit hypothetical, but I think it was discussed before. These two questions, maybe I will need to get your reflection, a quick reflection on that in the Q&A session. The first one, we have discussed this before in many occasions, that we have about 180,000 refugees in Malaysia. Yeah, so they are registered. What is the current sense? I don't know whether maybe COVID is the right time that we have to revisit this again and see whether that makes sense, that we're now observing them in our formal employment sector. So that's one. And the second question, second reflection could be the company's sense of now, or business proposition for government to, rather than start new recruits from origin country or from whatever the source countries, now we are expediting the process for the regularization process for the undocumented migrant workers. So these two talents are already in Malaysia. We just need to leverage them, having a good system in place so that we can pave the way for their inclusion in the labor market. Yeah. So
point taken, Doctor, and I will address those during the Q&A. Yes. Thank you very much.
Thank you very much, Dato'. Now we the role of trade union, because we know we have CSO, we have MEF play their role. Government has their workers for working for workers' voice, the grievance channel and all that, and CSO have their own platform as well. What is the role of trade union in addressing and preventing labor standard non-compliance in the business sector? That's the first one. And what do you see the emerging labor issues, which you may have already received from your member? I think you have more than 500,000 of members. And how do you see the role of trade union in ensuring that the forthcoming NEP BHR is able to address the issue that you are facing now with your members? It's like 3 questions in one, Mr. Effendi. Hope you have about 10 minutes for reflecting that. Thanks, Mr. Effendi.
Thank you. Terima kasih, Doctor. I can answer all the 3 questions in one slide. Actually, thank you very much for giving this opportunity for the MTUC to share. So, of course, our view, Doctor, or the panelists are more on the employees or workers side. And for your information, we are not represent only 500,000, but you are present almost 16 million workforce in Malaysia, also including migrant workers in Malaysia. So in all sectors we have. And for your information, also we have the collaboration with the ILO, and we also have the our migrant resource center. So most of we are focusing on the issue of most of the human rights, on the issue of the child labor and forced labor. So talking a view from the challenges from the workers side, that we see that the challenges is we see that companies see that human right is mainly as a stakeholder and ethical issue. A business case for expressing human right focus on more immediate cost and the benefit is less widely accepted. So the connection between profit and human right is hard to make for employers, and it's an ongoing struggle where to draw the line. So the companies are still coming to grips with what their responsibilities mean in practice, a process that will also take time. So the current leader in corporate actions on human rights have moved ahead by embedding the respect of human rights with their organizations, but the knowledge that there are still have so much room to be learned. So on the constraint on the step of reform of company policy and communications, such as externally are very slow now. So not widely practiced in all sectors, and has been practiced by big operation, but MPCC for it be for our view, for it be efficient, need to be applicable to, let's say that on the small and the big businesses in our country. So from the view of the workers prior to the COVID-19, so migrant workers, we are already most among the most vulnerable in the world are various forms of the exploitations. And one of most common issue, one common form of exploitation is withholding and theft of wages. So the pandemic severely escalated the situations. While some brands, retailers committed to pay in full complete order or those already in production, others responded to the crisis by the cancelling order or paying suppliers sufficiently reduce the price. So this has had advisory financial impact on the suppliers and also return back to the workers. So workers are being forced by employer to take, in the current pandemic, to take unpaid leave or reduce wages, confined to poor living conditions, and giving the little choice on the worker. I agree with Dr. Lada say that, but this is the current situation that because we also have the problem in the employer and employee side in the pandemic. So when talking about the forced labor, it's often associated in the exploitation of the workers in private sector supply chains. So this is an age-old issue linked to the slavery and patterns of economic exploitation that has been regency in the recent time. So taking supply chain and tracking product is a material link to such form of the exploitation might help prevent the integrity of brand by systematic state-imposed abuse will require a border joint strategy from the company, from the government, and from the investor, and also from the human rights group and also NCO. So on the imaging issue, we see that it's related to the business sector. So human rights risks have a growth ground as a government developed the crime prevention method and technology to tackle the spread. In some cases, treating the patients as the potential criminals. So the regulatory frames and educate. So COVID-19 response in many instances suffer from lack of transparency. There's a question over the accountability and the surveillance. Adding further complexity, tests for the virus are not always accurate. Some policy go so far in monitoring people alongside concern about the responsibility of business conduct. So the employees monitoring, including movement and proximity tracking, is mounting concerns. So the COVID-19 has changed how our work now, how we work now. It has led to the re-examining the tools we need to work and technology at our disposal, and how we understand how the work-life balance. This is significant implications for the human rights. The year ahead will need a greater intention, so ensuring that redesigning a workspace and building the better and concentrate on people and their human rights. So, like to say what is about on the business sector, but the best practice within the area of labor, the commitment to respect human rights from the top level. So businesses are written a policy commitment will both set the tone of environment where human rights are taken seriously and facilitate development of more detailed policy and procedure to honor this commitment. A strong policy commitment is one on the approval at a senior level, communicate both internally and externally, and reflect of the business, human rights expectation of the supply partner and other associated third parties, including by specific minimum labor standard. So implement a human rights due diligence process. The detail of company human rights due diligence process depends on the size of business and the nature and location of its operations and supply chain. Due diligence should include assessments of direct business impact as well as border communities impact that directly result of supply chain, business operation, product and services. The following steps are important element of the human rights due diligence process. So the mapping of the supply chain for resourcing of the raw materials and subcontracted manufacturing and accessible by the finished goods and the end user. So the assessing the risk level of each step is the supply chain based on industry, raw materials and location, and identify area of the enhanced due diligence and developing internal external process to audit and monitoring the global supply chains according to assess risk level. So the assess actual and potential human rights impact. So the assessment of the human rights impact is ongoing process which business should undertake when they embark a new activity, a new business, or supply chain relationship, and put immediately thereafter. So it should be involve the human rights expert, including meaningful or consultations, potentially affected group and other relevant stakeholder. Factor to take into account is assessment, including the human rights human rights risk in the country of operations, the nature of the supply chain, and the industry-specific risk. So what's integrated upon the findings from the impact of the assessment. Once a business identified the human rights impact in important step or outlined below, the keys of the prevent those impact and when possible to mitigate the adverse human rights impact by the other involved parties. So with involvement of the legal counsel, internal stakeholder, and where possible, affected the populations, create a roadmap to help and prevent the activities causing the adverse impact. So provide the employees training, guidance, and identifying the preventing detection of human rights impact, including training and applicable business policy and process, and mandate and enforce respect for human rights in the agreements with the third party. And last on our side is report on human rights performance engagements. So communication information is a step of company to take the compliance with human rights standard, demonstrate a good faith and accountability to the public. So human rights reporting may incorporate information on the range of topics, including business structure, supply chain relations, and then policy commitment respecting the human right due diligence process, and a specific update on the key of human rights. So last but not least, on my presentation, that overall to answer your question is to allow of the union of better to allow the formation of the union for better protection of the workers and provide the bargaining power, that will advertisely lead to the better protection of the rights of workers. Thank you, Doctor. That's one on my view on the workers. Hopefully, answer your question.
Yes, you have answered that, I think, quite perfectly. So just a quick reflection as well, Mr. Muhammad Effendi. As we speak today, we have MOHR, we have CSO, we have ILO, of course, being the technical expert in this space, and we have MEF. One thing that we have not actually covered is the social compliance system and the actors that involved in either certification or external audits, right? Because they have the legitimacy, go to the company as we can do, I can do, CSO can do, but they have access to workers, right? They do the regular auditing and all that, but we haven't bring them here. We haven't brought them here in this dialogue. But I would just like to see whether trade union would have a plan to engage and also bring on board the social compliance actors, certification bodies or auditors to be part of your initiative so that we have all encompassing actors within the labor issue so that everyone knows what we do and we can complement to each other. Maybe because we don't have a question specific for Q&A, maybe Mr. Effendi can explain a bit what is your plan about, engaging with social compliance system or the actors so that, we have a full visibility of what in terms of resources can be shared or expertise can be shared, etc. Yeah. So for that, thank you, Mr. Effendi. Maybe you can reflect that in Q&A. Now we move to the last speaker, Mr. Adrian. Now, I think Mr. Adrian has been very actively involved in managing cases, advocating for the rights of workers. Now, migrant workers are among the most, I think you would know that, you would appreciate that, among the most vulnerable segment of workers. Yeah, of all the segments of workers that we have in Malaysia, they are among the most vulnerable. For the past few years, there have been allegations of rights violation against migrant workers. Yeah, I'm using allegation because some of it are still allegation, but some of it actual exploitation. Yeah? And do you think that, number one, the question, do you think that we are doing enough to protect migrant workers in Malaysia with the whole range of amendment and labor reforms being already presented by Mr. Bashar just now in the first panel? And how do you foresee the NEP BHR can address these issues? Because this has been years in our eyes and under our radar, basically. How can we address that with the NEP? So the floor, the screen is yours, Mr. Adrian.
Good morning, everyone. Is my sound clear?
Yes, clear.
Yeah.
Clear.
So, thanks for giving me the space to share. Even though North South Initiative is a social justice and human rights organization, we do play a role to a certain degree in auditing and even looking at the supply chain. So some of the things that we see in the whole supply chain, of course, we can't share the details. They make us sign very thick NDAs, but it's the reality. It's very messy and complex. For me, I would like to remind the whole system that migrant workers are not meant to displace or replace local workers. But over the last 30 years, this has become the trend. So it has become a very comfortable way of utilizing the human resource. When we check salary slips, we can see 12 to 16 hours of work, non-stop work every day, work on Sundays, work on public holidays. So if you look at the neoliberal economic model, naturally an employer would prefer a migrant worker over a Malaysian because the output is much higher. And in my observations, some companies are even willing to pay much more. The problem with the business and human rights discourse, it has become academic over the last few years. With due respect to everyone, has become academic. Malaysia has been dragging her feet for a long time. And I have a few critical reflections. For example, the state duty and the corporate responsibility. In Malaysia, from some of my studies and audits, there is a conflict of interest between these 2 points, because you have state-owned enterprises that that own or even have invested in some of the companies, and uh, when we launch cases with full due diligence and with full evidence, Andika, even though you say allegation, I mean, even with black and white evidence, there's minimal to no action taken, because some of these violators are either owned or directly GLCs themselves. So when GLCs don't play or become the role model, I mean, how can we expect the small and medium enterprises? Like Freddie, you said there's like 600,000, but you have GLCs and on the American blacklist. So they were red flags during the COVID time. That not to say that these are new issues; these are very old, 20-year-old issues. Personally, I'm an observer for 20 years from my university days in 2000. It's just that the COVID highlighted some of these issues, and some of it is quite scary. It shows that the political will is not there. I have seen legal notices from investors, and things can't continue as business as usual. And don't wait for business and human rights document or action plan to be fulfilled. There are other more scary things that are going to come our way, and the reform has to happen now. I think if you look at the statistics from the Ministry of Health, I think some of us were there in the ASEAN Forum on Migrant Labour, and only about 1.2 million migrants had just received their double dose of vaccines. if you look at the estimate number of undocumented migrants, that's about 2 to 3 million who haven't been vaccinated. So, and that's quite scary. And then you look at the number of migrants who got COVID during in the work cluster. It's a very dangerous overrepresentation. If I'm not mistaken, more than I actually have the statistics. Yeah, 65% were non citizens. So we have a crisis, and we need to deal with it. There have been some attempts to normalize or equalize the playing field. For example, the introduction of SOCSO to migrants. But the policy is still that health subsidies have been removed for migrants, and the virus doesn't discriminate. If migrants are not healthy, our fellow Malaysians who work with them are also going to get infected. So we can't propose, we can't discriminate. And as long as there's discrimination in terms of standards, practices, that's where the exploitation will continue to happen. So we need to make sure that there's no discrimination. And according to the Malaysian plans as before, we have to reduce our dependency on labor migrants. I remember during the water supply problem, when the water was contaminated, I think it was exposed that there were about 4,000 to 5,000 illegal factories in Selangor itself. Now imagine who's the human resource behind this, and I'm glad that we talked about informal labor. But for migrants, it's more tricky. If you are informal or you have lost your job for whatever reason, you become in a very precarious situation. I've seen the supply chain which when it went bust, this global supply chain, not SME, they told the workers, you either go back, you join the recalibration program, or you just abscond to other sectors. So it was very messy. And we even had one industrial court case where the company, it was quite funny, I had a good laugh. They said that the instructions for the minister was confusing, and they had to send back a migrant worker 1 year before his contract finished. Of course, we fought and we won the case. The worker got about 11,000 in compensation, which is minimal. The reality is migrants, we need to ensure that it's a fair level playing field. We need the data. We need more data. We need to look into the whole supply chain. I'm not sure. To be honest, from the CSO side, we have been proposing a national comprehensive policy. I think what will be fun to observe is how Malaysia is going to adopt the zero recruitment fee. And the only reason now that why companies are paying up is because the Americans are holding a stick. And, their audit companies are saying, oh, don't worry, just dump 20,000 ringgit down the throats and the migrant will be happy. But that's not justice. We have the principles of Rukun Negara, and that's not how justice should be defined. Money is not the answer. The people who violated their rights, who abused their rights, needs to be accountable. So back to the business and human rights principles. Besides the conflict of interest I mentioned earlier between the state's duty and the corporate responsibility, there's also a problem in access to remedy. In the supply chains that I helped to look into, the investors, the brands, the tier 1, tier 2 are totally confused on who should bear the responsibility and the liability. So it's quite funny. Oh, you pay the bill, you pay the recruitment fee. I mean, when I go to the field, even middle management doesn't understand what due diligence is. This is all alien language to them. What is business and human rights? So there's a lot of work to do, friends. This discussion about flexibility needs to be taken very carefully because businesses, it's easy to hire, easy to fire, but for the migrant in Malaysia, we must abolish this kafala-like system. And we believe that this is the way to go. I think Qatar has already looked at it. Maybe one of my last points was I think we were part of the study where we were looking for gender responsive policies, and we couldn't find any. I mean, it's quite disturbing because if you look at ESG standards, you now have diversity, equity, and inclusion, but we haven't even started or with the basics gender responsive policies. I think Shanti will have a few critical questions. She's in the crowd. So there's a lot of work to do. Still very messy. Just don't wait for the lawyer's letter. It's not just products. It's also services and even facilities that are being monitored. So if Malaysia wants to remain competitive and not lose investment, we have to change. Otherwise, my advice to investors is to think twice before you choose Malaysia. Yeah, that's my initial reflections. Thanks.
Thank you very much, Adrian. I think it's quite reflective and thoughtful as well, I guess. We have a lot of work to do. Okay, let me just check on the chat box whether we have. So now let's move to the Q&A session. I think previously I have already, sort of provide you some upfront question for you to reflect. Maybe let's start with Mr. Basha first, because I was initially asking about the question about ratification for ILO Convention 190 on violence and harassment. Just to note that the question was raised by, I think, Ms. Shanti, if I'm not mistaken, Shanti. And there's another follow-up question on ILO Convention 100 on equal remuneration, which has been ratified by Malaysia. Speaks of equal pay for work for equal value, but local laws are not adopted to operationalize this principle. So basically, there's no domestication of that commitment, and this is essential to reduce gender wage gap. And any explanation for non-operationalizing of this principle? So the question is that what is the explanation of not domesticating this, this principle? So we have two questions for Mr. Basha to reflect, maybe about 2-3 minutes, Mr. Basha, if you can.
Okay, thank you, Doctor. I try to answer the two questions. So for the first one, at this moment, MOHR giving priority to ratify Protocol 29 exactly on force level, in line with Convention C29 that we have ratified since 1957. So, as we all know, the processes of ratification of C190 needs a lot of clarification, discussion, negotiation between all the parties, and MOHR will start the engagement to dealing with C90 way forward of ratification or whatsoever. That's for the first one. So for the C100, that's Malaysia ratified, already ratified. National Wage Consultative Council Act 2011 not differentiate wage by gender or others way. So we treat under the acts as equal treatment in the wages. So furthermore, MOHR through Minimum Wage Council under the National Wage Council Consultative Act 2011 is in the midst of reviewing the minimum wage order as stipulated under Section 25 of the Acts. The report is expected to be finalized by end of this year to be submitted to Cabinet for the final stage. So maybe that's for the two questions, Doctor. Thank you.
Mr. Basha, if you can also reflect, if you prepared to reflect on the gig economy, or what's the plan from MOHR in terms of strengthening the social protection for informal workers in the gig economy? Is there a plan?
Okay, for the gig economy, doctors and others. So under the MOHR, we have a Self-Employed Social Security Act since 2017. The acts cover all the self-employed, including for the gig economy, such as e-hailing, bus driver, lorry drivers, and we extend it to the all informal sector since 2020. Okay, that's all.
Okay, got it. Thank you very much, Mr. Basha. I think if we have more questions that relates to your mandate and function, we will channel that to Mr. Basha, if you don't mind. Yeah, Mr. Basha. Now let's move to the Mr. Guachayan. I think we had raised a question about whether SME do need a free pass or flexibility, and Adrian also highlighted that what kind of flexibility that we are giving, because we need to also be cautious about the actual business environment. So. And there's another follow-up question, I think, from Mr. Muhammad Mustaqim. So the question, let me just read the question so then easy for Mr. Guachaya. So because of COVID-19, problems such as supply chain and manpower rose in companies. So basically they happen in companies as well. And in order to provide trade with the EU or to have a business relationship with EU, companies need to follow the EU regulation, including labor and environmental due diligence, etc. Now, if the companies were to follow this regulation while having challenges during COVID-19, so we have two responsibility at the same time, would EU accept the lower quality products? So I don't know whether Mr. Guachayan can reflect that a bit for these two questions. The screen is yours, Mr. Guachayan.
Yeah, thank you very much. I think on your first question, a very important question given the percentage of small and medium enterprises in the total number of enterprises, and the importance and the relevance in the economy in Malaysia, as well as their weight when it comes to the generation of employment, and of course because it is at the enterprise level where decent work takes place. So I mean, this is a very important question. I mean, how to reflect small and medium enterprises in the National Action Plan on Business and Human Rights of Malaysia. I think, I mean, since this stage, which is the designing stage of the National Action Plan, is key to engage the relevant government institutions. I mean, it is key to engage the agencies as well as the ministries, departments, which are dealing and supporting the small and medium enterprises from different angles. It has been already mentioned, and I will touch upon this in a bit. I mean, by previous speakers on the social compliance, which private compliance, and also the linkage with the public one. This, I mean, it's important to have the relevant government institutions on board, and this has to do very much with the initial message that I mentioned in answering the first question, which has to do with coordination and partnerships and the engagement also of the respective trade unions or workers' organizations in the country, as well as the business association in the discussion, in the assessment, as well as in the design and definition of concrete actions to be allocated in this action plan. The second point, I mean, here important to mind and be aware of the fact that many companies, many of the micro, small, and medium enterprises are informal, and therefore, I mean, the conventional tools or conventional strategies might not be effective for that purpose. They might be also invisible, many of them present in the lower tiers of the supply chains. So how to recognize this informal character of the small and medium enterprises in the National Action Plan on Business and Human Rights, this is critical also for this segment of enterprises to be included in the National Action Plan. Let's remember that the small and medium enterprises lack economies of scale. And when it comes to the implementation of the labor dimension of CSR, responsible business conduct, this is important because, I mean, for a multinationals usually have dedicated resources, but also entire departments, professional staff dedicated to navigate the complexity of compliance, of CSR, of regulations, international regulations in the context of FTAs and investment. That is not the case for small and medium enterprises. So there is this lack of economies of scale, but also asymmetries of information in the sense that many times small and medium enterprises are overwhelmed by the different codes of conduct, the different social standards that they have to comply with, also different initiatives in the private compliance segment. I mean, the specific codes of conduct, plus of course the national legislation. So these two aspects, the lack of economies of scale and the asymmetries of information, require the intervention of the public, the public policymaker, the government, with public goods that can support this segment of enterprises to better incorporate the responsible business practices, but also for them to conduct due diligence, and therefore there is the need to come with tailored tools. And when I say tailored, not only tailored to the nature of and the size of the companies, but also tailored to the sectors, because due diligence, I mean, is very, very different from sector to sector, and the issues, the peculiarities are different. And I would say in this aspect, which touches upon, of course, social compliance, private compliance, and the compliance with the national legislation, it is important to have the accompaniment and the engagement of the workers' organizations since the beginning. I think it's important for, there is a number of companies, CSOs, association, international companies, that implement these codes of conducts, then put into practice, and then also generate these reports. But it's important for them to involve the workers' organizations, those representing, of course, the formal sector, but also the informal one. So I think this would be important to take into account in the National Action Plan. On the second aspect, I'm not in the position to respond from the International Labour Organization whether the EU is going to accept lower standards or not, of course. But what I can say is that there is an emerging trend in legislation, which is mandatory legislation related to due diligence on human rights. Recently, in June this year, Germany adopted its own law on mandatory due diligence on human rights, and is requiring, well, the German companies as well as their respective supply chains, which very often are present abroad, to comply with standards related to environment, but also to the social aspect. And when it comes to the social aspect, it specifically relates to labor, to the labor dimension, to international labor standards, fundamental principles and rights at work, as well as principles present in the three instruments that we will see later on, the UNGPs, the guidelines of the OECD, as well as the ILO MNE declaration. So I think, this is a trend. Many companies are adapting themselves. They shouldn't see it as a requirement, but it's actually part of their business, their own strategy of competitiveness, their own strategy of resilience and survival, but also their own strategies to address risk related to labor. Thank you.
Yeah, thank you, Mr. Guachayan. Let's move to the question that being raised to Dato' Shamsuddin. The first one is the refugees and inclusion of refugees and undocumented workers in our formal employment labor market or sector. The second question, I think there's a question about, I think this is quite an important question as well, raised by Ega Elias from Malaysian AIDS Council. So the question, we work on the rights of people living with HIV, of course, and we have around 88, PLHIV, so basically people living with HIV, like, despite the fact that HIV is now a manageable condition with treatment available for free at government clinics. HIV has no risk of transmission with treatment, yet many employers and companies deny their right to work, especially for people living with HIV. So maybe Dato' can also reflect on this question, these two questions.
Yeah, terima kasih, Dr. Andika. Yeah. The first issue on trying to actually utilize the existing resources that we have in the country. One is those people that are considered as refugees, and the other one is people who are here, but on what we call it as in the Malaysian context, illegal status. Yeah? And of course, on the first one, of course, is, the refugees. I think MEF is all for the employment of these people, formal employment of these people, and they should be allowed to fulfill the requirements of human resources in the country, as they are already here, and there is no need for us to actually bring in new foreign workers to the country, things like that. But I think the major issue here faced by the government is basically the trust deficit on the validity of the UNHCR cut, because there are a lot of, complaint, a lot of findings that the cut being carried by the refugees are actually fake. Yeah. So how do we address this issue so that at the end of the day, those people who are really refugees are actually being classified as such, and they are eligible to be employed by the Malaysian employers. So that, I think, is one of the critical issues currently being faced by the UNCHR and also by the government. So how do we address this kind of trust deficit? So at the end of the day, I think those people who are already here, they are actually eligible to be employed on a formal basis. Sad to say, currently, of course, these people are normally doing a lot of self-trading, especially at the Selayang, Pasar Burung, thing like that. But again, during pandemic, it became a major issue when actually the authorities actually have a major crackdown on these people. And I think now it's going to be very difficult for them to really make a living and also trying to make ends meet. So the other part is basically when you talk about refugees, of course, they are supposed to be here for just a few years to be transmitted to another third country, thing like that. But in the case of the Rohingyas, especially, they had been here for the last 30 years kind of thing, or even 40 years. And some from the Tok Nene up to the Cucu now, they are still around here and things like that. How do we address this kind of situation? Yeah, so this, I think the government and the UNHCR has to really find ways and means trying to actually resolve this, I would say, a long time standing issue. But of course, if they are actually allowed to be employed, then of course they can actually be meeting up some of the human resources needs of the country. But I must say also that the refugees are a bit picky on the kind of jobs they are expected to do, in the sense that, we had a pilot project involving plantation company, thing like that. Well, of course, they are put actually quite at a remote area. And out of the so-called 50 employees being tried on as a pilot project, none actually stayed in the company. So that was, I would say, complete failure. And as far as the issues of the recalibration program, of course, yes, on paper, it looks very nice. It tried to attract those people who are illegally in the country to be regularized. Yeah? But if you look at the details of the requirements for the illegal workers and also the employers to actually legalize them, I think it's very difficult for us to meet those requirements. And that's why I think if you look at the data now, I think less than 150,000 had actually enrolled in the program. And we know that you and I know how many actually illegals are in the country, but of course, these are all guesstimates. Yeah, some of the people say that for every one legal foreign worker in the country, then we would have, say, for example, 1.5 or even 2 illegals in the country. So of course, the question here is that with so many illegals in the country and only about less than 150,000 enrolled in the recalibration program, surely it's not going to meet at the end of the day the human resources needs of the country, because we are saying here that, of course, for certain sectors of the economy, yes, we still do require the foreign workers. Not that we love as employers to employ foreign workers, but at the end of the day, we resign to the fact that locals are not interested in certain jobs. Say, for example, the plantation sector had been crying to say that, okay, look, there is a shortage of about 40,000 fruit harvesters. Yeah? And what the government had done recently was, because of the losses suffered by these companies, about 10 billion ringgit on a yearly basis, because they couldn't pick the right fruits. Then of course, the government recently announced that they will bring in about 32,000 new foreign workers. But of course, then we are leaving aside the kind of the so-called illegals that are, I think, big in number in the country. So I would say that as a policy, we should actually utilize the existing resources that we have in the country. There's no need to bring in new one. So I would say that there is a need to really open up the recalibration process. Never mind whether you have papers or you don't have any papers, because basically many of the illegals in the country are those people that come in without any papers at all. They don't have any passport, they don't have any documentation, thing like that. And to expect them to actually get a proper passport from their respective embassies is going to be very, very hard. And of course, apart from that, it's very costly. They don't have the resources to do that. So I would say that then we as a country should facilitate the processes so that we can assist them in trying to deal with the foreign embassies to get the proper papers to be done, and allow them to actually remain in the country and work and contribute to the human resources needs of the country. I think, and also all the sectors should be allowed to actually engage them if possible. So what I suggest here is that all the illegals that wish to be considered as legal workers, then they need to register, and employers that require their services can also register. And at the end of the day, there is no need for us to penalize anybody, because currently I would say that we have a very, very, I would say, funny law to say that if an employer were to report about the abscondment of a foreign worker, then you are penalized with 250 ringgit, as if it is the employer's fault for when the foreign worker concerned absconded. So I think this kind of laws need to be really relooking like that. And as far as, of course, the issue of HIV, people with HIV, of course, we always feel that I think as employers, you're always being criticized, you're always being demonized for not wanting to assist the people with HIV. But let us be frank about the whole thing. Yeah, when an employee actually contacted HIV, he wouldn't want to say, yes, I want to stay with the company, I want to work. The first thing he will do is that he will just withdraw himself. And he don't want to talk to anybody. He don't want to talk to the employer, he don't want to talk to anybody, because they say that this is my condition, this is my confidential information, I just want to keep it to myself. So in that way, of course, there is no way the employers can assist. I know a lot of I would say, policies being drawn up to say that employers should evaluate and monitor the situation, thing like that. But if the worker infected with the disease don't want to share the information with the employer, how can you expect the employers to actually assist? Yeah, because we are not open about the whole thing. You just want to just keep it to yourself. And of course, yes, we understand the issues of confidentiality, thing like that. But if you want to keep it confidential to yourself, there's no way the employers can actually try to assist the employees infected with HIV. Of course, we know that with the advancement in medical science, thing like that, yes, we are able to control HIV now, and of course, you can put proper safety measures, kind of thing. Yes, employers are ever willing to actually adapt and adopt to that kind of new requirements. But I think the people with HIV need to actually be sharing the information with the right people, so that the right people can do all the action plan and so plan their stay in the company. So thank you very much. So.
Thank you, Dato'. Thank you, Dato', for your response. Now let's move to Mr. Mohammed Effendi. The role of MTUC in complementing or adding or provide added value to the social compliance system in Malaysia. If you can reflect that, a quick one, Mr. Effendi. I think Mr. Effendi, you're still muted.
Okay.
Okay.
Thank you, Doctor. Actually, talking about the role of MTUC, actually, we have the two groups to assist the workers, migrant workers, also refugees. We have the two groups consist of cooperation between ILO, like I said, that ILO MTUC by establishing the Migrant Resource Center in Selangor, Kuala Lumpur, Penang, and Johor. So this is the collaboration project and the ILO project to ensuring that Migrant Workers Center is play a role in assisting migrant workers, especially in Malaysia. And the second, we also have a group that is a cooperation. We carry out the Source Center, which is also carry out the responsibility to have all groups of migrant workers in Malaysia, including migrant workers, migrant workers and so refugee in Malaysia. So in the pandemic, for your information, that MTC we received more than 21,000 cases involving the virus problem related to employment. So also related on the violence on the labor right, also unpaid wages, unfair terminations, poor working conditions, and employer require worker to continue working in jobs that are non-essential. So in the pandemic, this is the case. All the case we are reported to the labor department for investigations. So we have so many cases on the unpaid, and also in certain case we also involved in the police and also local authority assisting the migrant workers. For example, in this July 2021, there's the MTC with the intervention of the police for the D3 anti-trafficking in person, the Department of Labor. So I think this is the role of MTC to assisting them. So, but they have a few challenges that you see that the migrant workers challenge access a legal mechanism in Malaysia. First is challenges at the workplace. Second, social challenges. Number three is challenges in assisting the legal redress, like Dr. Samson said that, and also challenges in the claimants' documentation and immigration policy. I think this is things that, like Dr. said, government must review back. And however, in whatever challenges, I think MTC will take the role to ensure the resolution of each case involving these migrant workers or refugee, including to help them to realize intentions. the governments. We have the tripartite discussion with the employer, employees, and also governments, and also through the government to the department level policy. So by the employer by itself. We also welcome to the initiative by the governments, by the MHR, by the apps for working for the workers. They want also the role of the part of within governments on also MTC. Thank you.
Thank you, Mr. Afandi. I think we have run. we have limited time now. I think let's go to the final round. I think we make it open for now. We make it free flow, and maybe I can, unless Adrian, you have anything to be fair as well to Adrian. You have a quick one before we go to the final thought, Adrian.
Yeah, so I think the migrants were left out of the employment insurance scheme. I think that is quite tragic, and also from the wage subsidy program. So when they lost jobs during the pandemic, I mean, I don't understand what logic did we use to exclude them from these programs. They contribute to the economy. The levies are in the billions. They pay GST, SST. They contribute in terms of rental and so many other factors. So I think we need to be honest with ourselves. And sorry, Dato' Samsudin, you are not being honest about undocumented migrants. Let's go and trace back the digital footprints, how they came in, the thousands of bogus employers who bring them in, and we can have better statistics. But let's look at the data. From all our cases, 90% are from cheating by employers, cheating by agents. We need to be honest about it. Otherwise, this problem will continue, and we'll be exploiting them for a very, very long time. Thanks.
Thank you, Adrian, for also being honest. Thank you, Adrian. I think that from the beginning that we have to be open in the session. I just want to highlight one question before we go to the final thought. Especially for Mr. Bashar, let's scroll down. For Mr. Bashar, there was a question from Kia Hui from the Earthworm Foundation, asking whether there are avenues for BHR stakeholders, especially on the labor side, to be involved in contributing to the NAP development, like the formulation process and the drafting process itself. Maybe Mr. Bashar can explain that if you have a plan for that. So maybe you can include that in your final thought. So I think we only have about 10 minutes. Maybe just for each speaker, you would have about 1 or 2 minutes, maybe just 1 minute now, 1 minute to provide your vision for the UNGP BHR. To what extent that we should include all these issues, or make sure that all these issues are covered in the NEP BHR in future. And also maybe for Mr. Bashar to also reflect the question from Earthworm Foundation. Mr. Bashar, we'll start with you.
Okay, thank you, Doctor, for the question. MOHR will invite relevant stakeholder and CSO to share the input and view on every NAP, including the BHR also. So I would like to answer another question on that. Is it MOHR can organize a session on equal pay for equal, right? So the answer is yes. MOHR through National Wage Council have to review at least the current minimum wage rate and other related matter every 2 years. So the answer is yes, we will. Okay, so for the I missed the one point on the C19 earlier. So I will share also the proposed amendment of the Employment Act. It will cover sexual harassment subsection, and also a subsection on prohibition of discrimination in the workplace. Okay, that's the two. And another one for the child labor issue, is a question or sharing. So we, MOHR, will finalize the draft of National Action Plan for Forced Labor first. Then after we finish it, we will continue with the National Action Plan for Child Labor in the next. Okay, so for MOHR, we will provide our best to make sure the National Action Plan, business and HR, for the HR success in the near future. Thank you, Dr.
Thank you, Mr. Bashar. Now let's 1 minute for Mr. Guachayan, if you can wrap it up. I'm so sorry, Mr. Guachayan, we don't have the time.
No problem. Thank you very much. Well, I think my message has to do that indeed the ME declaration, which is the only ILO instrument that provides guidance directly to enterprises, but also to governments and to workers' organizations, can provide concrete recommendations for the implementation of international labor standards, fundamental principles and rights at work, and take an opportunity of this crisis to redesign policies in a way that are more human-centered, and we can, as society, build back better. And in the case of Malaysia, contribute to the Malaysian economy, make it more competitive, make it more productive, and allow it to access new markets.
Thank you, Mr. Guachayan. Now I move to Dato. What would be the MEF broad vision for UNDP BHR in the future?
Yeah, thank you very much, Doctor, for giving me this chance. I think what is important is for us to look at realities of the situation, because I see more often than not, many of the policies are really contradictory to each other. Why I say this? First, let us just say, look at the issue of forced labor. One of it is to say that the foreign workers are being, required by the employer to work long hours without resting like that. But what is the reality? The reality is that the contract itself mandated that and requires the employer to provide at least 4 hours overtime on daily basis. That is the reality. And of course, in the event the employer refused to have that kind of contract, the labor attaches of the respective countries is not going to attest to that particular contract. That means that if we as employers refuse to have that 4 hours mandatory overtime, then there is no way the foreign worker will come to Malaysia, because then we are required to do that. And once they are here, are we obliged to give the 4 hours overtime? Yes. Why? Because if not, then they will go to Labor Department, and Labor Department will say that you as employees, you're at fault because your contract says you must give 4 hours overtime. So, but what is this? And then the international communities say that, okay, look, the maximum you can work, including overtime per week, is 60 hours. Whereas if you have mandated 4 hours overtime, then per week you're talking about 70 hours. So these are the kind of things, the reality that we as employers are faced. And I would say that as employers, we had been unfairly accused of actually forcing the workers to work overtime. This is the demands by the sending country, demands by the labor attaché. And of course, I think the government has to do something about this. And if they feel that, okay, look, it is not good to us or to have a contract of 4 hours mandatory overtime per week, per day, 4 hours, then don't have it in a contract, by all means. But nothing is done even up to this stage. And the issue of, say, for example, like freedom of choice to have the employer. What do you expect the employers to do? You know, that the contracts say that, okay, look, you must actually bear the cost of their movement from the source country to Malaysia. And it's not cheap, I say. And if they are here, then you say that, okay, look, the employee then has the choice the freedom to choose the employer. So what happened to the employer that actually borne the cost of moving the employee from the source country to Malaysia? And it is not cheap, I say. Sometimes can be 10,000 ringgit, sometimes can be 15,000 ringgit per pax. And of course, this is where sometimes we say that, okay, look, provided, of course, the second employer that want to have the services of this particular foreign worker can compensate the first employer about the cost of moving the employee concerned. But of course, this is not happening because the contract or the PLKS issued by the government is very clear to say that, okay, look, you work with this particular company, you work with this particular sector. And as an employer, you cannot actually run away from that condition being imposed by the authorities. So here again, I would say the allegation to say that the employees has no choice of employment is actually inbuilt into the system itself. And again, I say the Malaysian employees have been unfairly accused of not allowing the employee to move to a different sector or different employer. I think we need to have that kind of reality check before we accuse the employers of unfair labor practices. Thank you.
Thank you very much, Dato'. Let's move to Mr. Effendi. 1 minute of final thought.
Thank you, Dr. For MTC, that we, like I said before, we want to the government to allow the formation of union for the better protections of workers, as it provide the bargaining power that will the better protection for the and also for level protection for the workers, migrant workers, including those in essential services, in domestic workers, and also informal for all GIG economy job on those with illegal status. That's all. Thank you, Doctor.
Thank you, Mr. Mandi. Now, let's the final one, Mr. Adrian. If you can wrap it up 1 minute, your thoughts.
Yeah, so I hope that business and human rights discourse doesn't become an academic exercise, or it doesn't become business for auditors and lawyers to then come on board and continue ticking boxes. That shouldn't be the case. We need to ensure access to justice, principles of justice are at the core. Even now, we don't see natural justice. And of course, for migrants, there's also a very strong cultural communication competency that is always left out. And this needs to be factored in our plans, future plans. Thank you.
Thank you, Mr. Adrian. Now, I think because of the time limitation, so let me just wrap it up. 2 or 3 observations that I can pull out from this session. I think number 1 is the question relates to how do we actually prioritize the competing interests here? I mean, because people, whether we like it or not, I think interests are very competitive in nature. We have policymakers with different mandates, businesses with different abilities to adapt to new business environment, workers, union, civil society. I fully understand that this is not an easy task. I think only when we are able to actually complement to each other, then the competing so-called interests then become common interests. So the lesson and challenge here is, I think, how is then the NEP BHR and the expert in the NEP BHR formulation and the technical committee and all that can establish a common ground that aspires all of us from different angles towards a common goal rather than competing interests. Now, the second, I think, issue of labor may intersect as well with government. The other 2 foundation, that is the governance and environment, the thematic priorities. For example, the growing number of undocumented migrants may be also caused by lack of integrity, including in public procurement. So that is the space of governance. Yeah, I think similarly, labor issue may also cause or be the consequences of environmental issue, maybe in replanting in the farm sector, for example. Yeah. So the challenge is now, how do we ensure that the NEP BHR, as it is in the design, we have 3 thematic areas, capture these nuances and the connectivity between these 3, governance, environment, and labor, and that we are not just resolving one priority, but we're leaving another issues to grow. So I think that's the second observation. And the final observation is, we have already spoken about the role of social compliance sectors, the auditors. In fact, the training institution and certification agencies are yet to emerge during the discussion deeply. So I think the NEP BHR should also be able to count them in the journey, so that we are not leaving the important actor from making all encompassing changes. So with that, I would like to once again thank the organizer for allowing us to deliberate this session openly, critical but also constructive at the same time. I also thank all the panel speakers for contributing your thoughts here. And I wish all of you best of luck and stay safe. And also my apologies to participants who have asked questions, but we were not able to respond or reflect your question in the session because of the time limitation. So for that, I channel or pass back the session to the MC or the organizer. Thank you all.
Thank you.
Okay, I think we can start now. So, hello everyone, a very good afternoon. My name is Shivani Varma and I work with the UN Human Rights Office, the Office of the High Commissioner for Human Rights, regional office in Southeast Asia based in Bangkok. It is my pleasure to be here in this very extremely timely conference and an honor to moderate this very important session on the role of human rights defenders in advancing business and human rights. We've seen from the discussions, we've heard from the discussion since yesterday, that as we mark 10 years of the UN guiding principles on business and human rights, it is clear that business and human rights is a key issue in the current context, as we are at a turning point and inflection point for the future we want. Is it a future of closed borders, conflict, rising inequality, climate crisis, pandemics and discrimination? Or is it a path of resilience, inclusion, justice, peace, and prosperity? There is a deepening concern about the role of human rights defenders in civic society who raise issues of concerns or monitor or criticize or comment on human rights impacts of business operations, particularly and often in the context of large development projects that affect access to land and livelihoods. So this session that we have today will provide an overview and will look at discussing and exploring the role of human rights defenders in advancing business and human rights, legal, institutional, social, attitudinal challenges that they face in their work, explore some of the drivers and benefits of business actions, and discuss, recommend emerging good practices, bad practices, and possible solutions and way forward in relation to business and human rights. Our first speaker for today is Sevan Doraisamy, who's the executive director of Suaram. Actually, all of the esteemed panelists need little introduction, but as they're so well known in their field of work and advocacy on human rights. But just very briefly to say that Sevan is an advocate of human rights with over 25 years of experience fighting for human rights in Malaysia. In his years of defending human rights, Sevan has actively worked on areas related to freedom of expression, police accountability, arbitrary detention, and of course, defending human rights defenders. He himself has been detained 6 times for defending human rights and freedom of expression. So a very warm welcome to you, Sevan, I think as we discuss the role of human rights defenders, I think a very obvious question is, what do you think is the role of civil society and human rights defenders in promoting human and environmental rights? What do you think are some of the gaps in the partnership that exists or not between civil society and law and policymakers? And I think if I may just add to that question, what are some of your views on the allegations of intimidation and harassment faced by defenders, in particular in the course of protecting rights of Malaysia's indigenous peoples? So Sevan, the floor is yours.
Thank you, Shivani. Thank you for having me. Hello, everyone. I'm going to focus my presentation mainly on human rights defender and the role of civil society, as I've been involved in the civil society for the past 25 years. There's a lot of things we need to look into in terms of the role of a civil society they've been sailed through in many stages. Initially were not recognized and now kind of like recognized, but also not enough in terms of the questions goes back to how much the engagement with the policymakers, how much whether we are part of the institutionalized stakeholders engagement. So, but going back to the definition, the role of civil society often seen as the third sector intersecting between the state and business, but the scope and the activities, or mainly the role, is it's larger than one sentence as a third sector. If we go back to the UNDP's definition, civil society are the non-state actor whose aims are neither to generate profit nor seek governing power. CSO unite people to advance a shared goal and interest. That said, but civil society, there are two important parts in advancing human rights. As we all know, one is civil and political rights, and the other one is economic, social, and cultural right. Often, the civil and political rights group will be top of the mainstream, often highlighted in the media, where you work directly with the power. But the one group, not only they are vulnerable, but they also, their plight is not often highlighted in the mainstream, is the economical, social, and cultural groups. And those who are defending the economical, social, cultural rights are the human rights defenders, often not seen as a human rights defender, because in most of the time, they are the community leaders, not necessarily the older one, they're even the younger one. So they are the community frontliners, they are the community leaders, and they are the human rights defender defending economic, social, and cultural rights. So CSO is a group of people, organization with a guiding principle to operate for the common good of a society, environment in this case, or issue that they are working on, including labor or any other issues. Usually service driven with social actions, advocacy, campaign for the benefit of the people, community, as well as environment. Usually they are part of the state. They are not part of the state or the business or market. Always be the counterbalance to the power of the states. In this case, in environmental protection or in developmental programs or projects. They are the nearest network to the community for their communication to the power. In many instances, the community leaders, not necessarily the old one, are the frontliners of to protect their lands or fight for their rights, and fighting against the encroachment, especially for the indigenous community, fighting against the encroachment against their ancestral land, or protecting their environment. People work on the land rights or even housing rights. They are the most vulnerable group and often cut off from the mainstream. So they play the role to highlight the plight of the community, in this case, issue related to the protect environment, and organize actions to fight against environmental destruction, often related to land and development. CSO work within the framework of citizens' rights, community rights, environmental rights, and work within the framework of a rule of law, especially on the democratic participation. So I would consider there are 4 or 5 important areas for the civil society and their roles. One is empower and community participation. So where civil society play the role of not only catalyst, but they also have the role to empower the community and work together with the community. Without the community, the civil society can't function, especially when you're handling the economic, social, and cultural rights. So to understand their plight, their needs, and also empower them, and also try to mobilize resources and build a capacity for the civil society and also community to fight against their rights. And civil society is also playing important role in playing advocacy and also lobbying the policymakers to have a better protection laws and policies, and assist in the policy formulating as well. That's why we have, even within the civil society, we also have academicians, lawyers with a strong legal background to help and assist us to formulating policies. And civil society, like groups like Swaram, is also do a constant monitoring and reporting not only on human rights, not only in promoting human rights, also any human rights violations as well, and come out with a report, a related report. So the CSO's biggest role is to ensure, in terms of environmental governance, of a system based on participation, accountability, and equity, ensure the broad political, social, and economical issue of the marginalized section of the society is highlighted. Often, ideally, it is important for active and vibrant participation of a civil society, and in an ideal situation, CSO or human rights defenders plays the role that aim to protect the environment, such as collecting and disseminating environmental information, participating in agenda setting and policy making process by the government, and implementation of national resource management and environmental protection and advocacy. So this is why I'm saying in ideal situation, civil society is supposed to be part of the policy making, part of the planning and also implementation, but often neglected, or in the most of the cases, they have to fight against this, and we call this firefighting rather than being part of the whole process. On the second question of what is lacking, as that's part of what is lacking, definitely a political will to include the affected community, civil society organization, and other stakeholders and experts to be part of the planning from the beginning, and then collective decision making, and as well as implementation of any programs or developmental programs. Institutionalizing the engagement and adopting a democratic process is also lacking in the Malaysian context as well. On environmental protection, ecological accountability is a big question, and where the multi-stakeholders engagement and government's transparency in terms of engagement and a decision-making process is also lacking. In some cases where we directly experience the rule of law and environmental justice was not followed or often violated. And then in some other clear cases, one of the latest is the Kuala Langat North Forest Reserve Land. If you all know how much to and fought in terms of gazetting, de-gazetting, and re-gazetting, and even for a straightforward issue, this is a reserve land, it's a gazetted. But then they had a plan without including the people's participation, and then they made a decision on their own. And we also seen in terms of environment and also land, there's a huge power rely on the Menteri Besar or Chief Minister of a state, and it's often kept to that small group of elites, not by the people. And then the other question is on how you view on allegation and intimidation. So this is one of the area and many of my colleagues are here directly involved in terms of intimidation and harassment. But in terms of human rights defenders working on the economical, social, and cultural rights, and also environmental front, from Amazon up until Borneo, they are the most vulnerable and most in high-risk category, where in many cases, although we have some records in Borneo, where the case of Bill Kayong died or was killed, and also Bruno Mansur, there's some other unreported cases, but this is the highest risk, as I said, from Amazon to Borneo, those who are protecting their land's environment facing this risk. And other issues, often like police intimidation, in some of our friends who raise blockade to against their ancestor, encouragement of the loggers towards inside their ancestral land when they try to blockade. They often face a lot of threats, especially from the police, the forestry department, and also the thugs of these loggers. And they are deep inside, and they are very vulnerable, and sometimes end up with physical assault as well. And then in many instances, they've been arrested just when they only wanted to defend their land. So they were arrested, and then the arrest not only stopping them from staging the blockade, but also allowing the encroachment to proceed, allowing the loggers to proceed. Although it's debatable whether the loggers are given the license to, but this is not the way to resolve this. This shouldn't be the way where you arrest those who want to block, challenge the process, and then you allow the process goes on and arrest these people. So this is the usual scenario in terms of human rights defenders and community leaders trying to protect their land as well as environment from encroachment. They also often have the split and rule, divide and rule tactics, where they select few from within the community and probably bribe them to split them. And this also create a lot of unsafety situation for the defenders. And also some mechanism they wanted to raise, if like, for example, who they bring the issue of misconduct of certain enforcement agencies, in this case, forestry and also police. That's another area where often the police reports was neglected and then it was not properly investigated. So that's why the civil society organization working on the civil and political front, they're always demanding for the independent police commission. Right now, all these enforcement agencies under the Enforcement Agencies Integrity Commission, EAIC, and for our surprise, one of the important enforcement agency was not under the purview of EIC, which is Forestry Department. So where do they go highlight their issue? In most of the cases, we brought these cases and complaints to the national human rights institutions who are come, and also in many other instances, we need to highlight with the working group with the UN and find a way to highlight this issue in other means, which very much limited. And often the community leader rely on civil society organization in these cases. Another threat is also the court cases or either the logging company or any other businesses. They sue the community leaders. The latest one is Shakoya, is known as Shark. Also from the indigenous community defending their rights. It's been summoned by a popular business. I don't want to mention the name here, but he received a summon yesterday. So this is another way of constant intimidation using legal means, using the court process to threaten them from continue doing the work with the indigenous community of fighting for their rights. And also the departments which meant for, in this case, indigenous communities welfare, JACWA, often play the role of the state and taking the side of the state, or in some instances any developmental project, rather than bring up the plight of the community residing there, in this case indigenous community. And we also have other laws which was often used against human rights defenders in Malaysia: the Sedition Act, Communication and Multimedia Act, Penal Code. They use the big name that detrimental to the parliamentary democracy. Even you try to defend your human rights, and in some instances, office been raided, and although the use of security law against this is not that rampant, but because of this security law is wide coverage, because of it, it can be always misused against human rights defenders. That's another worry which the government have used against human rights defender using SOSMA and all these security laws. I can stop here and I can take more questions after this. Thank you.
Thank you, Sevan. Thank you so much for that. And you're absolutely right that there is this deepening concern on the nature and type of threats, criminalization that human rights defenders are under either at risk of or facing directly. And I see there are a lot of issues that you've raised which merit individual discussion on their own, from accountability mechanisms to lack of political will and planning. And I think your comments on particularly the concerns you raised on land and forestry issues, and of course the rights of indigenous peoples, we will of course explore that at length also when we have our other panelists, Assemblywoman Jenny, speak particularly on the issue. But I see there are no questions in the chat box for now. So maybe I do have some questions, but maybe we can pass over. We can move on to our next speaker and wait for a little bit more questions to come in, and then we can get back to you, Sevan. So thank you very much. Our next speaker is someone who is very well known in not just the legal advocacy circle, political circle as well, for speaking out his mind as the other defenders. So we have Andrew Koo, who is our next panelist. He was called to the Bar of England and Wales by the Honourable Society of Gray's Inn in November 1991, and to the Bar of the High Court of Malaysia in May 1995. He is also the co-chair of the Bar Council Constitutional Law Committee. So participants, start gearing up and drafting your questions that you want to ask him in relation to the Constitutional Law Committee. So Andrew, a very warm welcome to this session. The question that I would pose to you would be also a very natural follow-up to what Sevan said as well, with a specific focus on public participation and inclusive engagement. We know that these two lie at the heart of effective implementation processes of social environmental laws and legal frameworks. And of course, in the context of not just business, but other activities as well. But of course, within the context of, if you look within the framework of the guiding principles on business and human rights, we have the concepts of right to access to information, to participate, and access to effective remedies. So what my question to you would be that, do you think Malaysia is doing this sufficiently in terms of, ensuring that there's right access to information, participate in effective remedies? And a follow-up question to that would be that what do you think about the current level of engagement between civil society and businesses and civil society and human rights defenders? We know that Sevan has shared some thoughts on how there is a gap. We would like to sort of hear from you more as to what do you think businesses should be doing more to engage more with human rights defenders to promote respect for human rights. So the floor is yours, Andrew.
Shivani, thank you very much, and thank you to the organizers for inviting me. I want to observe all formalities and greeting dignitaries that may be present here. And I also want for us to pause for a few moments to remember Professor John Ruggie, who was the author of the UN Guiding Principles on Business and Human Rights, who passed away on Malaysia Day, 16th of September, 2021. May he rest in peace, and may we continue his work in trying to advance business and human rights around the world. So I'm going to share my screen, hopefully. I don't do this too often. And so sometimes I'm never quite sure whether it will work. Is it working?
Yes, perfect.
Okay. So I think one of the topic that I was addressing was the central role of human rights defenders in advancing business and human rights. And really to answer your question, Shivani, firstly, I would like to build on what Seven has said. And although you mentioned that I'm a lawyer and things like that, human rights defenders are not just lawyers. Right? They are everyone. They're you and me. And by understanding defending, it's really to promote, to protect, and to defend. And all of us will do a whole range of different things. So I've just let my mind loose and sort of type out all the different adjectives that or adverbs rather of things that human rights defenders in general can do, and we do one or more of any of these things in our different ways. And so if you think that you're not a human rights defender, I would challenge you to say, well, rethink. I think you are one. And I'm going to sort of frame some of the things I'm going to say in the context of this thing called the United Nations Declaration on the Right and Responsibility of Individuals, Groups, and Organs of Society to promote and protect universally recognized human rights and fundamental freedoms. And this was adopted unanimously by the United Nations Human Rights Council in 1998 on the occasion of the 50th anniversary of the Universal Declaration of Human Rights. And basically it's shortened because it's such a long title. It's basically called the UN Declaration on Human Rights Defenders. But I wanted to show you that although we've reduced it to human rights defenders, it really means individuals, groups, organs of society, everyone to promote and protect human rights and fundamental freedoms. And so, so what is it that human rights defenders ought to do? Right, and this is where you talk about are they enabled or are they empowered to do their work? Well, I think you just have to look at the declaration, and I've taken this really from the declaration, and these are some of the rights and protections that the international community feels ought to be accorded to human rights defenders in order to be able to do their work. So Seven very helpfully talked about some of the challenges, some of the problems, some of the threats that have been put in the way of human rights defenders. And I think Wachla is going to talk a little bit more in the context of the media. But if you can see, it's basically a repetition of fundamental liberties, from being able to do your work either individually or in association. So that means being able to form associations. So even a neighborhood group standing up for, preserving their park against housing developers, those are human rights defenders at work. Whether it's a group of nurses or hospital workers trying to come together, even within a COVID situation, to say, look, don't ignore us, don't ignore our rights, don't put us at the back of the queue when it comes to vaccinations, because we are hospital cleaners and we don't rank with the nurses and the doctors. Those are human rights defenders as well. And people, young people, in going to the corner of Dataran Merdeka, talking about Undi 18, those are human rights defenders as well. So the whole idea is to be able to freely meet, freely assemble. This is an important part. Seek, obtain, receive, and hold information, and then to develop and discuss ideas. So there is a free flow of information. So restrictions about information, restrictions about so-called sensitive issues are all, in a sense, putting barriers in the way of the work of human rights defenders. And if you go on down, to be able to complain, to be able to submit things to government agencies, to complain about official policies, and then not to be investigated by the authorities because you have made the complaint. I mean, that's again not something that that ought to happen. And then to have unhindered access to communications, and then to also to be able to benefit from an effective remedy. I'm moving down now because time is passing. And so there ought to be laws that civil society can engage with and demand to be applied in order that the work can be done. And I think we'll come back to this if we have time, but that's a very important area. And then of course getting resources and even funding from abroad should not in and of itself be criminalized or restricted, subject to the usual regulations. So these are some of the things that civil society ought to be able to do. And so I think we can all reflect, looking at this list, whether or not we do actually enjoy this in the fullest and most unrestricted ways possible. And of course, if we don't, and if we can't, then there needs to be a rethink in terms of how the authorities and how business interests also engage with civil society. So the flip side to the rights and protections accorded to human rights defenders is the duties of the state. And again, what you'll see is these are duties that are imposed on states, not just because of this declaration, but through many of the human rights treaties that countries have signed. Because Malaysia is a bit of in a very poverty-stricken situation when it comes to human rights treaties, because we've only signed up to 3, and even then with huge significant reservations. But again, these are actually in the Constitution, right? So if you want to talk about constitutional law, any and all of these things are actually provided for in the Constitution. Unfortunately, in the Malaysian Constitution, what the Constitution gives with the right hand, it kind of takes back with the left, because you say, you can do this, but you can do this, although, so there are lots of freedoms that are granted, but then there's also a lot of space for which Parliament is empowered to make laws that restrict the exercise of those rights. And so I think one of the challenges for the state, and I hope there are people from the government in this breakout room, to look at how exactly can we reduce or even possibly eliminate some of the restrictions that are in place. So things like sedition, things like sensitivity, and again, the whole thing on media comment and freedom of expression and right to information and the right to share information, all that I think Watzlaw will also cover. But all that is part of the duties of the state to facilitate. And also the state has a very important duty to adjudicate between the rights of individuals and the rights of businesses. And I think that's where, again, Seven talked about it earlier, about how, say Orang Asli complain about encroachment on their land rights, and they go to the police to complain. And then it's the companies that also say, oh, there's trespassing, there's encroachment on land that's been given to us by the state. And who gets locked up? It's not the company directors, it's not the company managers, it's the, Orang Asli human rights defenders, the leaders of the community, who are merely, standing up for their rights and trying to protect their livelihoods and the interests of their community. So there is a balance. So where does business come in? Well, one of the things that I'm going to repeat is that business and human rights is not a new thing. It didn't just drop out from the sky in 2011, 10 years ago, when the late John Ruggie, got to work on guiding principles of business and human rights. I'm going to skip a little bit and show you a slide, right? When I say business and human rights is not new, look, we have legislation that dates back, you know, if you want to talk about the 1920s, the 1930s, the 1950s, it's all there. These are the laws of Malaysia, right? And they go back, even if you want to skip the 20s and the 30s, look at the 54, the Aboriginal Peoples Act, 55, Employment Act, 63, Fisheries Act, 65, National Land Code, 1966, we already had legislation about workers' minimum standards of housing, right? You know, people say now, businesses say, oh, you know, it's COVID, you know, it's too expensive to enforce the new regulations on making sure that migrant workers have adequate space and decent living conditions. Well, you know, there is some sympathy. I have some sympathy for you, but not a lot, because at some basic rules, some basic minimum standards have been in existence since 1966. So, you know, if you want to come and complain that, oh, you know, it's unfair to impose it on us now, well, they're not just being imposed on you now. They were imposed on you a heck of a long time ago. And what have you been doing about it? So, you know, and then even things like environment. So, you know, in the 70s, there was all these things about environmental protection. So you see in the 70s, you have the EQA in 74, you even have the planning laws, so Street Drainage and Building Act, Town and Country Planning Act. All of these things were created back in the 70s. And so we think of this as laws, but actually these are laws to protect human rights. Maybe, you know, we didn't make the connection when these laws came up. Nobody taught the language of human rights. But if you look at what they deal with, they are at the core of human rights. They are at the core of dignity of individuals. They are at the core of protecting resources, protecting our environment, protecting working environments and working standards and safety at work. So you even have in 67 Factories and Machinery Act to talk about, you know, making sure that you have protections against machinery so that they don't cause harm, you know, to workers. So let me go back to whether or not there is enough engagement. Well, those of you who represent business and enterprises in this breakout room, look at some of the things that you're doing and ask yourselves, do you consult with stakeholders? Do you consult with your workers? I mean, it's interesting that we have followed in our boards of directors in companies the Anglo-American model of shareholders and appointment of directors and things like that. But if we were to look at some of the European models, so let's say the German model. So in the German model, on the board of supervisors of a company, which is equivalent to the board of directors, you have mandatory representation by the workers. So the workers' councils in a German company have automatic seats on the board of supervisors because they are part and parcel of the enterprise. And then there's also engagement with society. So it's not just your customers, because of course customers are important. If you do something wrong with your products, your customers are going to run away. And even China understands that. I mean, we look at China and say it's not a country that's great on human rights. But when it comes to food security, they understand human rights. You know, when we read stories a few years ago about, you know, bad milk coming from New Zealand being sold in Chinese supermarkets, you know, then they start talking about food security and food safety. Well, that's part of human rights too. So, you know, Seven quite rightly talked, we tend to focus far too much, perhaps, on civil and political rights, but there are economic, social, and cultural rights as well. So why is it that we don't have a minimum standards of healthcare and access to affordable medicines act? Right? We don't have that. We have a Peaceful Assembly Act. We have, Elections Act, voting laws, and things like that. But we don't have a healthcare act that guarantees minimum access to healthcare and medicines. And so any company that is in business will have to deal with some or more of these issues. And I'm sure we'll talk about this some more. But I want to just end by for this round by just looking at some of the last 4 points on this particular slide. So, I'm an armchair economist in the sense that I took economics for A levels, managed to get an A in it. I don't know how. But one of the things we learned in A-level economics was about internalizing externalities. So you look at your simple demand and supply curve and you say, oh, the cost of production is going to be my labor costs, my capital costs, things like that. And most of the time, we don't factor in consequences of our products. So for example, if you manufacture a product and you do a lot of pollution, if you don't factor in the cost of remedying that pollution into your pricing, you underprice your goods. And therefore you give a false economy, literally, of your demand and supply. So one of the things that all of us needs to do is to look at what are the social and consequential costs of the products that we do, and are we correctly including that or representing that in our pricing. And so we've had laws, I showed you that slide, we've had laws from back in the 20s and 30s, but unfortunately for Malaysia, our laws have not kept up with technology, not kept up with developments in science, and also with new international rules. And unfortunately, our companies are quite happy to take advantage of that low standards because it means less expense to them to keep up to date with technologies, up to date with compliance. And we have the cases, and I'm sure you are familiar with them, of companies from other parts of the world coming and opening up businesses, heavily polluting businesses in Malaysia, because they can't do it in their home countries, because their home countries' laws are much higher. So they come to Malaysia and they do it because they take advantage of our low standards, right? And they quite happily say, oh, we are very law-abiding corporate citizens because we comply with the laws in Malaysia. And I'd say that's true, but you're actually taking advantage of the fact that your home jurisdiction has higher laws, more expensive laws to comply with, and you're running away from that and you're trying to set up in Malaysia. So I'm trying to say that lower standards are not a comparative cost advantage, right? You are actually, the cost is still there. It's just that it's being paid by someone else. And we'll talk about SLAP later because I think that's quite important. So I think where's the engagement? Where does business engage enough with human rights defenders? Well, my answer to that is look at this list and ask yourself, if you are here representing a business or an enterprise, how much of this do you do? And if you're not doing this or you're not doing enough of this, then the answer, I think, is pretty obvious. Thank you.
Oh, thank you. Thank you so much, Andrew. And I think you've put it across as explicitly as it can be said, that I think one of the major concerns about the role of business is also in causing, contributing, or being directly linked to or affiliated to the creation of an environment that is seen as detrimental to the work that human rights defenders do, or in failing to take action against or failing to ensure that such an environment is not perpetuated. It's very interesting that you talk about and you pose us the question, is the legal framework or the lack thereof of a strong legal framework one of the key challenges that civil society and human rights defenders find themselves facing? Because it's not just, I think it's not just Malaysia specific. We see this trend globally where companies take advantage of weak legal structures and accountability mechanisms in countries where they invest. So what would be interesting, and I, if I may ask you a follow-up question on that, would be that, what are some of the what would you propose, or what are some of the measures that policymakers, civil society actors have initiated or are considering to explore further, particularly in ensuring that the legal framework is strong and that there are independent oversight mechanisms?
Well, Shivani, I don't know about independent oversight mechanisms, but I think in terms of the law, I think some of the laws have been progressively updated over the years. So, for example, I showed you the slide about the Water Act from 1920, but of course, we have more modern legislation that deals with water standards. For the Environmental Quality Act, the regulations, so not the law itself, but there are progressively new regulations. So when there are international conferences and state actors being regulators go and attend these, they are open up to, they are exposed to newer standards, newer technologies, newer ideas. And we see that to a certain extent coming home and are slowly implemented in Malaysia. But to me, one of the criticisms, and I think, with all due respect to the people working really hard on rolling out the National Action Plan for Business and Human Rights, one of the things that I would criticize Malaysia for is we take too much time in implementing new standards and new procedures. Yes, there should be ample time for industry consultation. There should be ample time for feedback. But we are pushing against a rolling tide that will just sweep us away if we don't upgrade ourselves. We can understand that in technology. So I mean, it's the hypocrisy, isn't it? To a certain extent, I would say. We want to be market leaders. So in wanting to bring out new goods and new services and to sell new technologies and things like that, we want to be market leaders. But when it comes to protection of our workforce, minimum standards of protection, we are quite content to be market followers. And if we can be really at the back of the queue, even better, because then it will take some time for Malaysian businesses to catch up. Right? So we have this huge lag time. And whenever the government introduces new standards, the first response from industry groups is, oh, can we have a delay? It's too rushed. We need time. It's going to cost us money. So as I said in my presentation, when it came to the so-called new standards in terms of migrant worker accommodation, right? The initial response was, oh, it's going to take us time. It's going to cost us money. It's now COVID-19 time. It's not the right time for us to do this. People are going out of business and things like that. Again, that's true. But the commitment to amend the act was actually done in 2015 when Malaysia was preparing to enter the Trans-Pacific Partnership Agreement. So if Malaysia had acted very soon after making that commitment in 2015, we could actually have had these new laws and these new standards in place by 2016 or 2017, long before COVID ever showed up, right? So what happened to all the cost savings that companies and their owners enjoyed in the years where we didn't make this mandatory? Right? Nobody's talking about, hey, cough up those profits because they were made unfairly because you actually deprived your workers of good housing. But now when it's COVID-19 time and you say, oh, we have no money, then you say, oh, please excuse us, please delay, or, please give us an extension to the introduction of these new standards. So I think it's the delay and it's the fact that our Malaysian industry is quite happy to leave the timing to government because they know that government will take time. And even with our National Human Rights Action Plan, when is it actually going to happen? When is it actually going to be rolled out? We're still talking about studies to be done next year, zero-based drafts to be done the year after, So it's going to be, well into the middle or to the end of this decade before we actually have an effective National Human Rights Action Plan for Business and Human Rights. And industry is quite happy to just, keep to that time frame because, less legislation means less cost of compliance.
Very well said, Andrew. And I think this just reminds me of what is currently at the heart of the UN General Assembly, which began, I would say yesterday, with the SDG moment. And but I think as discussions continue, I mean, we have the Secretary General who's really emphasized about the climate change crisis. It's now, and it's linked to a whole lot of business operations. But I think my takeaway from what you've said, you know, apart from, of course, the specifics of how laws need to be, how laws have been progressively updated. So there's nothing new. But I think what is important is to really emphasize here that the guiding principles or the laws and regulations that are related to business and human rights, it concerns risks to people, not to businesses. This is about people. This is about the lives of individuals who are affected by business operations. And I think it's important to keep that at the heart of all discussions that go into the drafting of the NAP. So thank you very much, Andrew. I do, again, I have, just as I have for Seven, I have some questions for you as well, but I'm allowing time for questions from the participants. I don't see any questions in the chat box, but be rest assured there are some coming from me as we move forward. So maybe without further ado, we move on to our third panelist, who is an esteemed journalist, media person with immense experience on issues related to freedom of expression, promoting media freedom and right to information. Vatsala Naidu is currently the Executive Director of the Center for Independent Journalism, which, as you all know, is a Malaysian civil society organization involved in monitoring freedom of expression, opinion, and also pushing for legal reforms, particularly in the repeal of the repressive laws which have been used to criminalize expression, dissent, as well as in pushing for the enactment of a right to information legislation. So, Vatsala, welcome to this discussion. And I think, again, a really interesting and a very natural, smooth bridge to what Seven and Andrew have emphasized. I think here it's, you know, talking about participation, information, transparency, accountability. What we would welcome is are your thoughts on, you know, what is the role of the media in investigative journalism and reporting, particularly on environmental, business and human rights issues, and you know, what are some of the challenges and concerns that you think that journalists or media people face in terms of restrictions on expression and publications on matters related to business and human rights. And I think just a short follow-up question to that would be, in addition to, you know, what you think is the role of media when reporting on environment, business and human rights, and what are some of the challenges that media personnel face, you know, how do you see some of these challenges being addressed in Malaysia? You know, are there any specific reforms, legal or otherwise, that you think that should be a priority for the country? So the floor is yours, Vatsala.
Thank you. Good afternoon to everyone. Shivani, thank you very much for the very glowing introduction. That's one thing I can't claim credit to, that is being a journalist. I claim the identity as a human rights defender. Yeah, and thank you for your questions, Shivani. To begin with, I mean, Andrew brought up the UN guiding principles. It's very clear that it recognizes the important and very, very valuable role played by human rights defenders. The key role that they have in human rights due diligence, and also to enable companies to understand really the concerns of affected communities, stakeholders, and as what was pointed out by Andrew, the risks they face as a result as well, right? And to also further emphasize, the reality, as pointed out by Sivan, despite these standards, the international standards that we have, the different approaches that we have, the reality is basically human rights defenders are in fact facing intimidation. They are facing harassment. They experience the use, how laws are being used against them, and especially where the legal system is being weaponized to penalize the defenders for their work. And this, of course, also includes strategic litigation against public participation. And it's within this landscape and emerging concerns that we locate the role of media as a key actor. Yeah. I mean, in theory, the way we look at media, they are, the fourth estate, the enablers for democracy, and they're literally the backbone in a way. They make sure there is effective, timely information flow. Yeah. And the role, of course, is also to inform, to criticize, and stimulate discussion and debate. So for media to be credible, it has to take the responsibility of getting its facts right? Hence the importance of ethical and responsible reporting, as well as the focus on investigative journalism. Now, in the context of Malaysia, and as well, I mean, if we can do a comparative analysis, the role doesn't really change, right? The roles contextualized within certain political dynamics, political landscape, and but by and large, in the context of business and in the context of business and human rights, media play a huge role in making sure that labor issues, labor violations are surfaced through their timely, fact-based reporting. Yeah, they are also the voices that will reflect the situation around, or the concerns around land matters, which involves both land appropriation, issues around degazettement, and we've seen many examples of this. Some of these, of course, also raised by Sivan, and one, just to contextualize it a bit, we also saw incidences where, when the state government had a public consultation on the North Kuala Langat Forest Reserve degazettement issue earlier this year, media was actually denied access to the public consultation, right? And then, of course, media would be the voices in making sure environmental issues around climate crisis is surfaced. And this role we've seen in many cases in Malaysia, just to name a few that are very, very public, the Raub Australian gold mine issues, the Linus issue, the Broga Dam issues. And these often also intersect with the role of human rights defenders and CSOs, right? And of course, the media has a key role, and I think we really do depend on the media in highlighting or reporting on corruption or alleged corruption. And this, of course, in taking on these roles to surface and to challenge the narratives around these issues, media, of course, do face challenges. There are threats to, their right to report. And these threats, of course, we can locate it within different scenarios. But if we were to look at it within the landscape of economic viability, where media's sustainability model in itself is a challenge to their survival, then it does place certain constraint on the role that they can take on, as the key messenger, I would say at times, for in channeling the information. Yeah. Another key challenge or threat we experience is the environment of secrecy in Malaysia, really. access to information is not as easy as in many other countries. We do not have a right to information legislation at a federal level. We do have two states in Penang and Selangor, which has its own respective freedom of information enactments. But there are, of course, still challenges because access is a huge concern. You might have the law, but you might not necessarily have systems in place which facilitates the access. Because we look to the state often, right, as the entity, the agency that would ensure maximum disclosure of information, particularly information of public interest. But this is where we face challenges because the information regime is not as progressive. This then links back to the broader legal framework that we have. So our culture of secrecy is further exacerbated by the fact that we have an Official Secrets Act, which basically rubber stamps most documents, rather arbitrarily, I would say, with confidentiality stamps. So in the case of using PM Sulit, right? This again restricts our access to crucial fundamental information. We also have laws or a legal framework that places national security imperatives as at the forefront. This then, means that certain draconian laws, such as the Sedition Act, certain provisions within the penal code are often used as a means to silence critical reporting, right? And then we look at the broader regulatory frameworks that media functions within, particularly the Printing Presses and Publications Act, which places very stringent requirements for licensing, yet at the same time, licensing can be suspended or terminated rather arbitrarily. Yeah, we also have the Communications and Multimedia Act, and particularly I want to emphasize Section 233, which with its very broad definition is very often used against media as well. We, one thing, in promoting the role of media or in pushing towards media freedom, one drawback is the way defamation laws are used against media. I could give you a whole list of cases. There are so many cases where they do experience libel suits, right? And then the other challenges that media face is, of course, in terms of protection of sources. And this is very crucial because if you are reporting on human rights violations, when you are reporting on environmental degradation, people come to you, with information, but protection of sources it's actually quite critical. Yeah. And again, we don't have a safe and enabling environment which will protect sources as well as whistleblowers. Yeah. There is also a need, I think there is a challenge because often media is placed in a situation where they have to draw clear demarcations between balancing the right to privacy and ensuring the full disclosure of information that is very, very relevant, particularly in matters of public interest. So, there is a balancing act that often, results in a way that to protect themselves against defamation and libel suits, then media do not necessarily proactively, conduct investigative journalism and make sure that the information is out there. And one of the other threats I would say is, I think the information flow and the information regime is very, very dynamic now. And then you throw in the social media platform, which creates another dynamic because you are now also in a place battling with disinformation, battling with how these platforms being used to propagate certain hate messaging, propagate certain narrative or propaganda. So in all these, media feels very, very challenged in making sure that they take on the role, in highlighting issues around business and human rights, particularly in highlighting violations. Yeah, I want to draw attention to two instances where media really came under threat when cases were filed against them. With recent case, the federal court had actually, in the case of Australian gold mining, and Malaysia Kini, in the defamation suit, the federal court actually dismissed Malaysia Kini's appeal, and the ruling actually came with an order where Malaysia Kini had to pay the mining company an additional 200,000 ringgit of damages, in addition to what was awarded by the Court of Appeal in 2018. I also want to draw attention to another very important case, because the decision here is shows a progressive way that courts can actually play a role in what I usually term as judicial activism, because they really have a key role to play here. In the case of PTZ Holdings Berhad and the Edge Communication, the High Court actually dismissed the company's case, right, on the basis of several defenses. But what I want to quote is a phrase that was in the judgment, which is the fact that journalists have the right and obligation to report on matters of public interest, even if these include negative information about companies. They should not be liable for libel or defamation if their reports are based on verifiable and reliable sources. Yeah, I do want to thank Edmund Bourne, for conducting these research on the specific cases. So in this context of this stress, how do we move forward? Because reform or positive measures does not just merely lie on the state. There are many stakeholders in this pond. Yeah, media themselves must always be recognizing their role, must always uphold standards. Yeah, they must observe the rules for responsible journalism to ensure that reports are objectively written and are based on verifiable sources. Yeah. And this is important because in addition to that, media has to recognize that there is a transformative role that they can take on in the way they present the narrative, and they ensure that it is not just one perception that is reflected. Because if we put on the transformative act, you have a social responsibility here too, right? And there needs to be a clear code of conduct, really, that not just addresses the standards, but also in a way provides certain protection for the media itself. And that goes to my next point on media. Self-regulation is key. In Malaysia, we really need to push for the establishment of the Malaysian Media Council, which would be a multi-stakeholder self-regulatory body, which will not just come up with a standard, but also ensure that the media is indeed held accountable to these standards. Yeah. Now I go to the reforms that must be initiated by the state. Yeah. Every other documents that we look at, not just the UNGP, but even the Declaration on Human Rights and most other human rights treaties, talks about safe and enabling environment. Yeah, and for human rights defenders, for media, this environment is crucial. And this environment can only happen if the state very proactively takes on the role of reviewing its existing laws. Because laws that criminalize freedom of expression, laws that criminalize freedom of assembly and association, and laws that, these laws need to be reformed. They either have to be repealed, or amended. And in this context, the state must also very proactively, facilitate an environment where criticism becomes part of healthy debate, yeah, on any issue. Yeah. And the next thing that the state must do, yeah, is actually to hold businesses accountable for any acts where it's an act of retaliation against human rights defenders, against media. Yeah. Now for instances where really media face challenges, or even human rights defenders face challenges where law or slap is used as a form of intimidation or harassment, I think there needs to also be a very robust legal aid mechanism that the state should facilitate and set up as well. Andrew mentioned the National Action Plan, but I concur with him, and I also want to add that the Malaysian National Action Plan has to clearly spell out the role of human rights defenders. And there cannot be any more ambiguity, and it should also include the necessary protection mechanisms that would be available. Yeah, I also want to raise the fact that states don't work in vacuum, especially when we're talking about business, right? So businesses have their own role as well. Yeah, and if we are looking at recommendations to businesses, the first thing they should do as part of their corporate accountability is to develop human rights defenders policies. And these policies must actually adopt a zero tolerance to any form of violence, intimidation, harassment of human rights defenders or media. Yeah, and there are many other global businesses, multinational, transnational businesses who have adopted similar policies. Yeah, so it's not something new. I think it's just something that the Malaysian businesses will need to really commit to as they move forward progressively. And in the developing human rights defenders policy or a human rights policy internally, businesses must also ensure that they have an internal grievance mechanisms, because communities at risk, communities affected by businesses, as the first cause of action, they always try to access the company directly first for discussion, for negotiation. So a company, again, with a robust internal grievance mechanism that is transparent and accessible will be able to resolve this at the beginning, at a starting point, rather than it culminating in a situation where the business will have to resort to other forms of attack to resolve these problems. Yeah. I also want to draw, in the context of businesses, the investors and financial institutions also have very important role to play. In facilitating funding, investment, asset management, they need to do appropriate due diligence. And in the context of due diligence, if ever there are instances or track record of human rights violations, then there has to be an accountability on the side of financial institutions and investors as well, to ensure that they do not continue supporting such businesses, or they should actually call out such businesses. Yeah. Now, another very important thing that we should encourage businesses in Malaysia is to be part of standard, multi-stakeholder standard setting platforms, and certification schemes that addresses, the whole supply chain. We have these standards at both global level as well as national level. Just to name a few, those in the palm oil industry, the Roundtable on Sustainable Palm Oil has standards around human rights defenders protection. They have a policy and they have a mechanism, and businesses, as part of the certification process, should really ensure that they uphold these standards. There is also the Forest Stewardship Council, and at the national level, the Malaysian Timber Certification Council, the Malaysian Palm Oil Council, just to name a few, should really, I would say, enhance their own standards and facilitate the resolution of disputes or complaints, between different stakeholders and businesses. Yeah, and finally, just to bring up the role of other stakeholders, of course, SOHACAM is critical, the UN and CSO. So there are different expectations in terms of their different roles, but they all have a role to ensure that whatever standards that are endorsed or applied or adopted creates also corresponding mechanisms that would support a resolution of complaints or disputes that arises between the different parties in the context of business and human rights. Yeah. Thank you.
Thank you, Watsala. I think there are two very, very important issues that you've raised in your presentation. Essentially, one is, of course, which raises concerns about the existing laws that restrict freedom of opinion and expression in Malaysia, and the issues of legality, necessity, and proportionality of these restrictions when speaking about the human rights implications, and of course, the disproportionate impact on journalists, media personnel, activists, and broader civil society. And I think it's very pertinent that you've raised that, these laws that a reform is needed, repealing or amending. And even if the government rarely utilizes maybe some of these laws, their very existence continues to have a significant chilling effect on freedom of expression in the country. And the other issue that you've raised, which is just so pertinent as we're discussing, the UNGP 10+, which is, a decade plus, is the issue of investor and financial institutions accountability, because in the first decade of examining the relevance or the utility of the UNGPs, I think a very important initiative is this development of a roadmap for meaningful action in the decade ahead. So UNGP 10+ project, which actually recognizes the critical need to shine a light on the role of financial systems and institutions in ensuring respect for human rights, from the AIIB to the ADB to the World Bank, and of course their links with different mechanisms that they set up in their activities in the countries where they operate. I do have a follow-up question, Vatsala, if you'll allow me, before we move on to our last panelist, which is, we've seen this trend also in these concern. I wouldn't say trend, but yes, we've seen in the past year, especially since COVID, how there've been instances of xenophobia and discrimination against vulnerable communities, particularly migrant workers. So, could you shed a bit of light on what role has the media played or should be playing in sort of stemming or putting it at bay some of these concerns or instances of xenophobia or discrimination?
Yeah. Thanks, Shivani. If we recognize, accept, see the role of media in reporting human rights violation, because it actually is a reflection of the society, and thus reporting these issues will actually also increase the awareness of the existence of such violations, and such narrative. In the midst of the infodemic now and information revolution, there are many great opportunities and ways for us to express ourselves, and for media and the different platforms that are available for media in sharing information and knowledge. But there are still concerns about the use and abuse of how these information is being channeled, right? In reporting xenophobia or biases, like this, bias narrative, hate narrative, media has a very important role, because by reflecting society and thus by increasing awareness about the existence of such thing, media is actually making or breaking the perception around these issues. They platform the issue, and the way they platform the issue influences the media. Right, and there's actually indeed a worrying trend here that seem to be perpetuating the bias, discrimination, and the hate narrative. And just within the last 15 to 18 months, we have indeed seen and re-emergence of the narrative around particular communities at risk. You brought up migrant workers, there are refugees. Also in the context of Malaysia's vulnerable communities, the communities at risk, also include the LGBT communities. So what we see is that the way certain media, say for example, issues around refugees or migrant workers, are using perhaps certain derogatory terminologies. And it's not as if these terminologies are coming from the media's general bias. It's also the nature of the media ecosystem in Malaysia, where there is of course state media, but there are also media with heavy political affiliation. So they do adopt at times the language adopted by politicians as well. So there is labeling, there is at times very exploitative messaging. Even in the context of, say, for example, LGBT, we often even see dead naming. There's, just the last few days, if we just look at our media in general, we can see how they've been portraying, LGBT issues and concerns. Yeah. And what this does is, in these conditions, minorities and communities are at risk are really rendered invisible. Their voices are unheard. And these very, it's not just xenophobic; it's also very racist messages that are being channeled through and channeled by media. Are actually increasing, and privacy is also breached at times, the way images are being used and locations are being named, right? And there are instances, we've documented cases where there's actually scant analysis of issues around migration and very little discourse around issues related to religious and cultural differences. And even at times, there are little attempt to relieve anxieties of societies, especially in this current context by economic and, the public health concerns, by the kind of language they use and the kind of portrayal of communities at risk, right? And of course, we do have the other side of the coin, where media can and have, in many instances, been the conduit or the mouthpiece of the voiceless, where they have, in fact, reported progressively in a very balanced manner, fact-based, yeah. But what happens in these instances, they do come under attack, because what this does is, of course, portrays certain actors in mainly state in a very negative light, right? So just last year, we've had a number of incidences where, foreign correspondents have been investigated or, being attacked online. We've had foreign media, being raided, its staff's work employment visas are not renewed. We've also, of course, had a number of, even local medias who are being investigated for reporting on issues around death in custody. Yeah. So this entire framework and environment and landscape either perpetuates these instances, allows it to proliferate in our media, including mass media, I would say, and social media, but it also adds additional expectations, I would say. I don't want to say challenges, expectations of media on how they ensure balanced reporting on one side, fact-based reporting on the other, but also to, as I said earlier, to take on a transformative role, because communities at risk need to be heard, but heard in a more positive way. And media can and should be taking on this role. And that is really the push towards this very progressive role that we expect of media, because media cannot use the constant argument, but we're just reporting facts. It's a quote from a politician. It's a quote from the residents. No, but you do have to acknowledge that by representing the issue in a particular way, media then is creating that particular narrative and perception that would influence. So there is always different ways of ethical and responsible reporting that takes the discourse to another level.
Oh, yeah, we're still on mute. Thank you, Watsala, for that, for sharing your thoughts. And I think without further ado, we'll move on to our last panelist, also in the interest of time. Yes, we have, I get a message already from our organizers that we are a bit racing against time. So our fourth panelist today, and definitely not the least, is Jenny Lasembang, who is a state legislative assembly member of the Kapayan constituency from the Democratic Action Party. Before joining politics in 2017, she was a member of the UN Expert Mechanism on the Rights of Indigenous Peoples, a commissioner with Suhakam, Secretary General of the AIIP, which is the Asia Indigenous Peoples Pact, the Secretary General of the Indigenous Peoples Network of Malaysia, and has worked for over 16 years as a grassroots trainer and organizer with a community-based organization on Indigenous people's rights in Sabah, PACOS Trust. So very warm welcome, Assemblywoman Jenny. And we are really pleased to have you join us. And I think, again, this is a very pertinent, relevant segue to the discussion on the issues that is on one of the key issues that has been raised by our other panelists on the rights of Indigenous people in the context of business and human rights, and in particular. We do know that there are particular specific risks that Indigenous peoples face. Their native customary rights, which are at risk or and are often violated in different forms during economic activities conducted in the pursuit of development. So could you elaborate on some of the roles and initiatives that human rights defenders have taken and can take towards advancing the rights of Indigenous peoples in Malaysia, especially in Sabah and Sarawak? The floor is yours.
Oh, so thank you, Shivani. Is my line clear?
Yes, perfect.
Okay, great. I'm doing this from the Sabah State Legislative Assembly, which is in session now. So sorry, I don't have the background either, so it's a bit difficult to arrange. But I'm happy to be able to join, and thank you for inviting me. Yes, definitely. In terms of the native customary rights, our human rights defenders, Indigenous people's human rights defenders, have found that these are, of course, relating to the customary land is one of the most pertinent in this issue of business and human rights. So the sort of things they have done, and I think our earlier panelists, because I think they've already given several examples, and Washala herself on some of the mechanisms that could be that they have been using. But one of the key things that they have done is to actually document the violation, document what are their concept of native customary rights, because that's the first thing that we see, and I think we have outlined that when I was in the Suhakam, when we were doing the national inquiry, where there's a lot of misunderstanding regarding customary land and native customary rights. They thought that, Indigenous peoples of Malaysia, especially Sabah and Sarawak, they just want to keep claiming, and so they will claim the whole of Sabah, they said the whole of Peninsula. So that's that fear that is created, that that Indigenous peoples and their native customary rights claims. So I think that is a fundamental, and that's why Indigenous peoples, and I think a lot of the NGOs have been helping them to document not just the violation itself, but also what they mean as far as their concept of customary land. And I'm happy to say, like Asia Indigenous Peoples Pact and community organizations have been collaborating with them to do this documentation. And of course, the roles, once you see violation, what they have done, the first thing they've done is try to now make reports to the police. If it's somehow involving corruption, the Malaysian Anti-Corruption Agency, these are important. But there again, many Indigenous peoples, as we mentioned earlier, they are the one ending up in jail, and not the the people that they complain. So it's really, I think, important that these institutions undergo reforms and be really independent to see Indigenous people's side of the story. media statements, especially now a lot of indigenous peoples are learning how to take documentation through videos and sharing it in social media. This has been quite powerful. And I'm happy that this has been also, our media has been much more open. Of course, there's still the limitation of space and for reporting, but it's already been improving. Now I think they have through collaboration with others, especially with the UN, and understanding the role of the various UN agencies in Malaysia, as well as at the international level. So indigenous peoples themselves have been, making reports through the relevant bodies. Most, I think, notably are the UN Special Rapporteur on the Rights of Indigenous Peoples, but also I think to various other UN agencies that, as Andrew was saying, we are very poor as far as the ratification is concerned. So there are only very few that we could access and actually give a formal report. But I think the Human Rights Commission, SUHAKAM, have been instrumental in also bridging this. And many indigenous peoples have found that SUHAKAM is one agency that they can go and make their reports. But still, despite the how people look at politicians, many human rights defenders do go to their political representatives to make their reports, to make complaints. And apart from that, making not so many, but still the grievance mechanism of, or say, for example, we heard financial institutions like the ADB, not so much, I think, on the World Bank, but these are, I think, now more and more coming in as they learn. Last resort that our indigenous people have taken, because it takes a lot of time, it involves cost, is taking court to case to court, and I think after going through Sabah and Sarawak, we have had and also in Peninsula some successes here. But there's still a long way to go. So more and more now, indigenous people's human rights defenders are being supported. So they are sharing, experiences with other indigenous peoples, how they file complaints, but also now taking courses. There are diplomacy courses, and to help them in terms of making their complaints heard. So I think basically this, Shivani, in terms of what roles and initiative has been taken. Thank you.
Thank you very much. And I think it's a really, again, a very good link to the next question. And I know we're short on time, but I think this is quite a pertinent question because you mentioned grievance mechanisms and I think my next question is really about what are some of your thoughts in the context of the recommendations that were put forward in SUHAKAM's National Inquiry report in 2013, which actually refers to the creation of an independent mediation mechanism for resolving land dispute between and amongst indigenous peoples and the communities, and also the Independent National Commission on Indigenous Peoples. So if you could shed a little bit of light on, what do you think has been the progress on this, and what are your views in terms of whether these mechanisms and the Commission would fit within the context of the third pillar of the guiding principles in terms of effective remedy?
Yeah, well, for me, the recommendations that were made by the SUHAKAM National Inquiry Report referred to the National Commission and also independent mediation mechanism to resolve disputes, such as the Ombudsman and the Native Land Tribunal. These are basically, to me, bodies that will deal with the systemic issues on land and territories of indigenous peoples, but they are not, they're more a dispute resolution between states or even companies and indigenous peoples, but not so much between indigenous peoples themselves. So I think we have seen some conflict among communities, but the dispute is more, of course, with cooperation. And even to me, I always insist, although this is always forgotten, that actually a lot of the dispute is also with government agencies. So to me, these are more those that I think mentioned under the third pillar of the UNGP, business and human rights, to resolve this. I think they need to be, I think between communities will be different. It might be that communities can actually find through, the traditional system, if it can be strengthened, the Ketua Kampung, or as far as Sabah and Sarawak was concerned, we have the native courts, and they have mediation involved there. Even now, the civil court does quite a bit of mediation as a way to resolve disputes. But I think when it comes to the business and human rights, it has to be, these are state, those proposed by Suhakam was more a state based grievance mechanism. Apart from that, I think we in Sabah, at least, we have this effort by the Sabah government to have a free platform consent guide in which there will be dispute resolution mechanism under the Roundtable on Sustainable Palm Oil, RSPO. And I think this will be also, this kind of mechanism will be useful. Thank you.
Okay. Thank you so much. I think it's definitely triggered an interest in me to now reach out to you bilaterally and have a discussion on how we can work on some of these issues together. We're completely out of time, and I think, in fact, we've gone over time. So I would like to thank everyone, the panelists, the participants, for taking out the time and patiently listening to us and engaging with us. And I think there would be no better way than to close this session in the words of Professor Ruggie, who had said himself that an authoritative global framework for action was only the end of the beginning. The challenge was to put it into practice, to create a common platform for action on which cumulative progress could be built step by step without foreclosing any other promising long-term development. And that is exactly what we have been collectively striving to do over the past decade. But of course, the other issue that I'm sure Professor Ruggie would have endorsed is that we need to, we're not interested in business as usual. We need business unusual. We need businesses to step up and take responsibility for today and tomorrow, work in partnership with civil society, young people, and to create stronger communities and resilient societies. So on that note, very promising and hopeful note, I thank you all very much. And it's been an honor to moderate this session. And over to Jehan, colleagues from UNDP who are here, I think.
We are going, thank you so much, Shivani. We're going to move everyone into the main room now. Thank you. Thanks all panelists.
Thank you.